Yeah. Welcome back to Sustained Overruled. I am the anonymous attorney. All right, so tonight we are talking civil forfeiture, okay? I'm over this watch. I really don't like talking about this watch, but let's get into it. And we're actually going to address the civil forfeiture aspect of it's not really criminal cases, but it is an extension of that. So let's obviously get into Weinstein because he is the uh, watch guy, because that's what he's mostly focused his cross examination on. And this, we're gonna start off. I mean, there has been a lot of speculation about this watch, okay? Some folks on the interweb were accusing an officer of supposedly wearing this watch on the stand, so it's been a hot mess. But let's get into it. Let's start with this cross examination of Ivorito.
Mr. Coco was going to show you a video. I just want to know if you recognize that video.
Okay.
Oh, yeah.
Let's get into it. A man's forgetting procedure. And we're gonna talk a little bit about what is this? I'm blanking. I was working today, y'all. I was working today. I got some hours in, so I don't have to do too much work over the holiday. I mean, it's only two. Is it 2 or 3 days? I don't know. But I hope I won't be working then. But we're gonna talk a little bit about gunpowder residue as well. Let's first get into this watch. You know I'm gonna be jumping around, so let's get into it. Am I sharing the right screen? Yep.
Would you play a piece of that?
Can I stop for a second?
Wow.
Or show my face on camera?
No, we're not going to.
Okay, I just
I'm
wanna
not
make-
going to. I'm not.
I just want to make sure.
I'm not going to show you.
Okay. Yes, absolutely.
All right, come on.
Okay, now I'm going to show you a still from the video.
Sure.
Okay, do you recognize?
We're talking about civil forfeiture. This is just the beginning because, I mean, it extends beyond the watch by itself, but this is going to form our background.
That?
I do.
And do you recognize the individual in that?
That is me. I do.
Okay. I am going to introduce EK15A.
And I would like to assume, because I thought this was a. I hate the fact that Weinstein focused the bulk of his cross examination on this watch. Um, I am assuming that he has chosen this as his um, main point of attack, show probably to show how corrupt law enforcement is in Fulton County and hoping for jury nullification. But I think he could have done. I just think he had better avenues of attack. In any event, we're playing this. We're going to get to the surveillance video, and then we get into civil forfeiture.
And it's redacted.
No objection.
Okay.
All right, and that's a still from the video.
Yes, it's
Submitted.
DK15A. It's a still from the
We can
video,
find the
and it's been
actual- okay.
redacted
Jumping
to
around.
remove the image of Investigator Viverito.
Thank you. It's
Okay.
submitted.
Would you please publish DK15A? Okay. Who is in this still image from DK15?
That is me.
Okay. Do you recall when this was taken?
That was on March 9th of 2020. I'm sorry, May 9th of 2022
And where was it taken?
at 355 Allison Drive, Northeast, Atlanta, Georgia, 30342.
And whose home was that at the time?
The home of Jeffrey Williams.
And where in the home are you?
Should be the master bedroom closet leading to the bathroom.
And in the video that you watched, which I'm not publishing again because it has your image on it.
Correct.
What are you doing at that point in the video?
We're inventorying the jewelry and items that are in the home.
Okay. And is this image that is taken that's part of your inventorying procedure in the home. Is that correct?
It's a documentation procedure, yes.
Okay. And do you recognize what you're holding in your hand in this still image?
Wait,
I
hold
do.
on.
And what are you holding in your hand?
A watch of some sort.
Right.
Okay. Do you know if do you recognize that as a Richard Mille watch?
I guess, yes.
And that's a pink watch, correct?
It's pink and either pink and light pink or pink and white, yes.
It's a pink band, correct?
Correct?
And it has a white ceramic, I'll call it the body of the watch.
White, yeah, I guess it's white if you say so, yes.
Okay. After you took this image
Mhm.
and you did this inventorying process, where did the watch go after this?
If you watch the video in its entirety, we're inventorying everything in the closet. There's a bunch of small boxes everywhere. So if you watch the video in its entirety, you take it and the watch is photographed like this, box is closed, it's taken and put up on the shelf in the upper left-hand corner, and the inventorying continues. And then jewelry starts getting packed up and getting ready for the evidence team to come and take it down to property.
Okay. Since November the 4th of this year, have you spoken to the state about this particular watch, the pink watch with the white band that I've been calling the Richard Mille or Richard Mille watch?
To the state, no, but I've seen the Twitter coverage of it going missing or whatever you want to.
Maybe
Well, no, I mean, there's a camera in here. They know that it's being live streamed. You just are not supposed to be watching it.
Oh.
And
Oh.
you asked that in the evidence. So
Well,
just keep moving.
I wasn't watching the trial, but my name.
Don't
and-
worry about it.
Okay.
Just keep moving.
okay.
Unless you need to approach about something else.
No, that's fine.
Okay.
Okay. So tell me, and I'd like to know about this. Tell me
It's
in the
thrown off.
whatever coverage you saw, what did you learn about this watch that came up in this trial?
Sustained. Well, yeah, sustained.
Okay. So after this watch was inventoried and you left it for, I'm sorry, who did you say takes the watch after the inventorying process?
So if you watch the video in its entirety,
Which I can't show here, but go
Right.
ahead.
but if you've watched it,
So what is ClickUp?
Oh my
ClickUp is an
goodness.
all-in-one productivity
I didn't think
software
it would
where you
all
can manage
ads.
everything and anything.
I watched it. The watch gets boxed back up and placed up on the shelf, and it gets left there by the team as as an accident. It was left there. The home was then turned over to Mr. Williams Sr. and Mr. Garfield Lamond to take possession of the home.
And is it the normal process when you're taking jewelry from the home or high valued goods that you leave behind a $500,000 watch on a shelf?
First, I don't know the value of it. Second of all,
That was a good response.
like I said, there were numerous jewelry boxes. It was, if you watch the video, everybody in there had on body cameras. I was made sure I was on camera at all times. There was cameras throughout the home. So you would be able to see if one of us removed a watch, the box remained in
All
the
right, so forfeit. No, let me let her finish, and then okay, I'm gonna let Viverito finish, and then we'll get into forfeiture.
closet. And like I said, the home was turned over to Mr. Williams Sr. and Mr. Garfield Lamond, who were the two people on scene that took custody of the home for Mr. Williams.
Okay, can we go back to my question?
Sure.
Sure.
Ask your
Is it the
question.
normal procedure to leave high valued items behind when you're doing a search and then a seizure pursuant to a warrant?
Objection out of relevance and
It wasn't answered, Your Honor.
overruled.
I don't know if there's necessarily a procedure on what you take or what you don't. Like I said, it got left behind. There were other things like other items of evidence that I had asked to be taken, such as photographs and artwork that had relevance to this case that were left behind by the evidence team. It was quite a big operation. There was a hostile crowd gathering at the bottom of the driveway, so we were trying to speed it up to get out of there.
So are you telling me that law enforcement has no procedure with what you do with high value items that are subject to a seizure warrant?
Objection out of relevance. It's asked and answered at this point.
Okay. So the watch you say was left behind. What else wasn't done according to your instructions at the home that day?
I believe there were two pieces of artwork that were, one was Mr. Williams in a general uniform with snakes on his arm, and then one was Mr. Williams as like Jesus at the Last Supper with all the people around him that I thought
Wow.
were relevant that were not taken. And like I said, it started to get pretty hostile out there. So we were trying to speed things up.
You said that there were many people with body cams in the
Correct.
home at the time. How many people approximately at the time
I think we're
of
done.
this raid of
Done
the
with the
home, let's
watch.
call it that, were wearing body cams?
Almost everybody.
And did these body cams capture Mr. Kendrick within the home?
I believe they caught Mr. Kendrick running from the home.
That's not the question I asked.
They caught him outside of the home. I don't know how to better. I'm answering
Well,
the question.
it's either a yes, no.
No.
Is there body cam image of Mr. Kendrick within Mr. Williams' home?
The body camera image I saw was him running from the home.
Is there body cam image of
No.
Mr.
Answer
Williams
yes or no, and then you can explain.
in the home?
I haven't reviewed it, all of the entry team's body camera, but no.
Did you see Mr.
Okay.
Kendrick?
So I think we've moved on from the watch. Okay, that's the only reason why we are watching this. Okay, so there's a distinction between a civil forfeiture as well as a criminal forfeit. I mean, the names kind of speak for themselves. So civil case, criminal case. But overall, the gist of the process is that the government is allowed, or law enforcement, let me put it that way. The government allows law enforcement to seize or take away property from an individual. Okay, in this case, obviously, we have Jeffrey Williams, and this watch there, man, they've talked about this, or at least what's his name? What's his name? Doug Weinstein has brought up this watch every chance he could, right? So the main distinction, obviously, it's the two different. One is civil, the other is criminal. In this instance, we are dealing with a criminal case. As far as criminal cases are concerned, the forfeiture is basically filed against, what is this? It's filed against the property. So in this case, the watches. I was trying to find the complaint. I should have taken a screenshot, or I should have downloaded it, or something along those lines, but I did not do that. But as I said, I was working earlier today. Again, it's been speculated that, or I guess at this point, they're really, or at least I wanted to say defense, but I don't think it's both attorneys at this point. But Doug is trying to impress upon the jury that the law enforcement in this case stole the watch. And I think that the reason why he is doing that is to impress upon them that they might be corrupt. That's what I'm thinking, because apart from that, the watch to me is of, I'm not going to say that's no, that would be incorrect. I'm not saying that the missing watch is insignificant, but as far as the charges that his client is facing, I think his focus should be elsewhere when it comes to cross-examination. But let's quickly move to a different officer. I was trying to find the officer that folks on YouTube, it might have been on other platforms, but I'm gonna say YouTube because that's what I watch. Some folks were suspecting that one of the officers actually wore the watch to court, which I don't know. It's a mess. It's a mess. But hold on, let me play this. I think it starts. No. No, hold on. I'm sharing the wrong page. I am sharing the wrong page. Or the wrong tab. Hold on. I think it's this one. Yeah, it's over here. All right, so we're gonna start. Am I sharing? Yep. So we're gonna start from here. I think I found the right timestamp.
Recall if ever reviewed that video or not. Okay, so you're not even certain if you've ever seen that video. I don't know. I'm not certain if I have or not. Okay. All right. Thank you. No further questions.
Redirect. Oh, okay.
Yeah, but she's not used to him. She's not used to Weinstein cross-examining, I suppose.
Good morning.
Good morning.
We have met. It's good to see you again.
Yes, sir. You too.
So I have some questions about what you said today. You mentioned that to Mr. Shart that Mr. Kendrick was present in the house at Allison Drive on May 9th, 2022, correct?
I don't recall exactly what his question was, but yes,
Okay. Did you actually see Mr. Kendrick in the house?
I did not.
Okay. The 6 guns that were found in that house, in Mr. Williams' house. Do you have any evidence that Mr. Kendrick was ever in possession of those that you
It's not
collected
that
or that
long.
was collected in that home?
All right, hold on. Let me just.
Do you recall, did you take part in the inventory, possession, or transport of the jewelry that was found in Mr. Williams' home?
My role during the search was to take photographs of evidence as it was recovered.
Do you recall there being 2 Richard Mille watches in Mr. Williams' home?
Okay.
I don't know if I would know those if I saw them. So I don't know if there were 2 or not.
Okay. Do you recall seeing it's a Richard Mille brand. I understand you don't know what that brand would look like, but do you recall seeing a white ceramic watch with a pink band in
And
the
I think before we actually dig into before we really dig into the civil and criminal forfeiture proceedings, we would have to go back to I should have thought about this before I went live. We're gonna quickly have to take a look at Jeffrey's plea to see what he pled to, right? Because I'd like to know if the court addressed civil or criminal forfeiture. I don't recall them addressing asset forfeiture. But because Jeffrey Williams pled guilty, and that's why I keep going on about um, guilty pleas on this channel, is because with guilty pleas, you definitely waive a number of your rights. So we need to look at that plea. We need to see exactly what it is that the court handed down as a sentence, because there's a great possibility that he won't be able. There's a possibility that his assets are going to be forfeited, just because of the plea. But let's get into this.
jewelry that you collected or that was collected in that home?
I believe one was. Do I remember seeing it? I certainly don't. This, a couple years later.
Okay. If a Richard Mille RM055 Bubba
I'm
Watson,
gonna look that up because I've never looked up this watch. She said what? I guess everything has an identifier.
if a Richard Mille RM055
Hold on. I think he said RM 0 something 55. Sheesh.
Bubba Watson white ceramic watch is not present in property today, do you know what happened to that watch?
I wouldn't have any idea.
Okay, thank you very much.
Okay.
Redirect.
So, okay, is it going to talk about the watch? I don't remember.
Detective Belknap, on cross, you were asked by defense counsel about the May 9th search of Jeffrey Williams' home. Do you recall that?
Yes, sir.
Now, you actually were the photographer of those crime scene photographs we walked through, weren't you?
Yes, sir.
Now, you remember being asked questions about, I believe it was the 6 firearms that you found in that house,
Yes, sir.
and if they have any ballistic evidence to the March 14th, 2022 murder of Shamel Drinks. Do you
Correct.
recall that?
Yes.
Now, how many
Are
months
you gonna
later was this search
redirect
from March 14th, 2022?
On the watch, no.
That'd be 2 months later.
Was Demekion Garlington arrested on May 9th, 2022 at Jeffrey Williams' home?
He was not.
Was Shannon Stillwell arrested on May 9th, 2022 in Jeffrey Williams' home?
No, he was not.
What about Miles Farley?
He was not.
What about Quarmadius Nichols?
He was not.
Now,
Remember all these names.
I want to also ask you as the photographer, I'm going to publish what's marked as 64 X-ray. It's going to come up on the big screen and on your computer. Is this one of the photographs that you took?
Okay,
It
where's the
appears
watch
to be.
though?
I'm going to go to 65 X-ray. Is this one of the photographs that you took?
It is.
Why did you take this photograph?
In documenting this scene, we saw this pamphlet for Mr. McMiller's funeral. Mr. McMiller was associated with YSL with Mr. Williams and had been shot and killed.
What was the date that he was murdered?
It was March 11th of 2022.
And do you recall if that murder was at a house or on a highway?
It was on the highway.
Is it, I don't have pointer, but on this whiteboard, is that March 11th, 2022 and I-75, 85?
Yeah, I believe so, yes.
And was Shamel Drinks murdered how many days after March 11th?
I believe it was 3 days later.
Now, I also want to ask you about, thank you, Mr. Vadi. You were asked on cross by defense counsel about a watch. Do you remember that?
I do.
Now, I'm just going to come out and ask you because we've been dancing around it.
Oh,
Did you
that's
steal
it?
any watch or know of any APD personnel who stole any item from that house?
Absolutely not.
Spoons,
Oh.
they're out. Panera's new ciabatta dippers are in. Each melty sandwich paired with a perfect
Can you tell the jury the protocols that are in place when you document, was everyone wearing body cam?
They were.
And can you describe for the jury the process y'all have when you go through that large amount of evidence on a scene like that? In terms of, do you video when you're putting it into property?
Yes, usually our body cameras will be running during the search of the home, during the transport, and at property when submitting property.
And were you all on scene or working that case for a short time or a long time?
We were out there for several hours.
One
Are
brief
you
moment,
done?
Your Honor. No further questions. Thank you, Detective Belknap.
Okay, that was pretty good redirect, but the watch is still. Whereabouts of the watch is still unknown. Let's quickly find. I just want to go over what's the guy's name? I forgot. I just want to go over the plea. I want to go over the plea to see if there was any mention. Okay, I should have found this. No, not watch. What am I doing? Hold on. Plea. I want to find. Okay, this is not. That's not going to be bueno. We want to see. Hold on. Is this it? No, that's ABC. So they're going to be talking about. I don't know. Let's go in there. I'm tired of searching. No, I want to find. Hold
shoot
on.
at your mammy, need to stand down. I up my stamina, take it.
Wait, what? Damn, love is something else. Hold on. Love is something else. I don't recall the.
I shoot at your mammy, need to stand down.
What?
I up my stamina, take it to trial, get an appeal, take it to trial.
Okay, I've never seen a plea
Pay
conducted
for
in
that
this manner.
casket.
Hold
That's
on.
just if we whack them.
I don't remember this. Why don't I? remember
YSL
this?
slimy and shady. Watch me whack that bitch, pop them like assist,
That's a mess.
block with the assist. It also consisted of a song wherein Mr. Williams sang or rapped the lyrics. Hey, this is that slime shit, that YSL shit,
Girl.
killing 12 shit, fuck a jail shit. I'm in the VIP. I got
What
the
is
pistol
loud
on
hit
my
going
hip.
on?
Fuck the police. You praying that you live. I'm praying that I hit. This that slime
I
shit.
watch. I mean, I probably caught the tail end of this. I do not recall the plea. Oh, but I focused. Never mind. Never mind. I did not watch.
100 rounds in a Tahoe. I'm prepared to
Love
take them
portion.
down. Got banana clips for all these ends acting monkey. This is that slime shit. This is that mob shit. Fuck the judge. YSL. This that mob life.
Okay, never mind. Never mind. I see what he's doing.
Defendant Williams released a video on YouTube of a
Yeah.
song wherein he states, I shot at his mommy. Now he no longer mentions me. Act like you want
That guy's
war
actually
and they're
pretty
going to
tall.
smoke you like a blunt.
Or maybe everybody else is short.
Another song, I escaped every one of the licks because I was supposed to be rich. I don't care nothing about a cop. I'm just telling you how it is. I done did the robbing. I done did the jacking. Now I'm full
Let me
rapping.
see if I can find. I'm gonna see if I can find the civil forfeiture. Yeah, let me find the civil forfeiture complaint while we're at this.
Gave the
One moment.
lawyer close to $2 million. He handles all the killing.
Hold on.
We don't speak about shit on wax. It's all my business.
My girl's a
We
hot
know to
mess.
kill the biggest cats of all kittens.
She's a hot mess. All right, I'm trying to find the civil complaint. I could have done this, but I was working. Let us see.
In another song, I was on Cleveland, stuck like a magnet, bitch ass N-word,
Mess.
pay for that casket. That's just if we whack them. In yet another song, Defendant Williams raps, red just like Elmo, but I never fucking giggle. YSL won't fold. Pick his ass off from the balcony, wipe N's nose. I'm gonna F for the cash, then she getting robbed by Tick, a reference to Trontavia Stevens. All I ever wanted was the money. Put your hands in the air if you dare. F and N, put him in a wheelchair. And even later on, Mr. Williams, and I believe that this was in 2019, made a post to YFN Lucci or Rayshawn Bennett. If I ain't like what you do for your mother and kids, I would have been killed you.
I think they repeated this. Okay, opposition brief. Hold on.
And in yet another song
Order
entitled
denying the trial.
Anybody, Defendant Williams stated,
Need to
I
go
never
back.
killed anybody, but I got something to do with that body. I got the streets on my back, carry it like I'm moving a body. I told them to shoot 100 rounds like he trying to movie the body. Ready for war like I'm Russia. I get all types of cash. I'm a
Compliance,
general.
discovery. No bueno. There's so much here. The only reason we're playing this, we're getting some background to see if there was any mention regarding asset forfeiture. Hold on.
As Mr. Williams' prominence in the
Loud.
music industry rose, his ascension within or in leadership in the gang YSL became more apparent as he rapped and talked about the crimes that YSL co-conspirators and members committed and how he got away with robberies. With respect to the Donovan Thomas murder,
Okay.
the court has heard evidence through phone records that within 6 minutes of the shooting of Donovan Thomas Jr., a phone call was made from Demise McMullen's cell phone to Defendant Williams' phone. And then immediately after that call, Mr. Williams calls his sister Dora Greer and then calls Kelvin Treadwell. There's then a series of calls between Dora Greer and Treadwell, and then Treadwell calls Demise McMullen or Nard. All of those calls happen within 15 minutes of the 911 call. And as I have stated before, the court has heard accomplice prior inconsistent statements about who committed the murder itself and what happened afterwards. The conflict between YSL and members of If Gang continued into 2019, wherein Mr. Williams raps the lyrics that I referred to earlier.
I'm just
In
searching.
May
I'm searching this
2019,
document that Ellie
a YSL
shared
member
with me.
shot multiple times at a vehicle owned by Rayshawn Bennett, a black and red Mercedes-Benz G-Wagon. At the time was being driven by a Milton Howard Jr. It was after that incident, later in August 2019, that defendant Williams posted on his page the language YFN, if I ain't like what you do for your mother and kids, I would have been killed you. The post was then deleted from his account. Through text messages of a co-conspirator, Marquavius Huey, there was communication between Mr. Huey and Mr. Williams, both in January and in September of 2020. On January 19th, 2020, Mr. Williams sent a flyer to Marquavius Huey with the performance location of Rayshawn Bennett or YFN Lucci. And when he sent that, he sent it with the message, handle that tonight, SLAT, SLATT. Mr. Huey responded, SLAT, SLATT. On September 2nd, 2020, Mr. Huey sent a flyer to Mr. Williams with another performance location of YFN Lucci. And Mr. Williams responded, Slatty, that is SLATTY.
Wait, am I tripping, or is defense not calling any witnesses at all? I mean, it's unrelated. I'm all over the place. But I was wondering because I'm going through. Did I just close it? I was going through the witness list for Jeffrey Williams, and I don't see one. I think it's really kind of foolish that defense would not. Oh my goodness, this is crazy. Hold on. I need to change screens quickly. Hold on. I'm going to change screens to my email. Hold on. I think this is it. Yeah, I'm sharing the right screen. I'm always with a mess. In any event, so this is Jeffrey's amended witness list, okay? And they have a bunch of all these people. I believe I saw his sister's name as well. They threw just a whole bunch of people on there. They have a cell phone expert. I personally think the defendants in the, at least as far as Shannon is concerned, but then again, they probably cannot disprove the evidence. That's another possibility. But I would have liked for them to put on either a cell phone expert, a GPS expert, just somebody, put somebody on. In any event, these folks, they had listed the judge. they had listed the judge as a witness or a potential witness. And then I think I also saw what's her name? I saw Adrian Love on here. Did I miss? Hold on, I just need to increase this because I cannot. Hold on, I thought I saw Love on here. Did I? Oh, there she is. They literally have Adrian Love as a witness, and then they have Ashley Merchant. I don't actually know much about Ashley Merchant outside of the Donald Trump election interference case and Fonnie Willis and Nathan Wade and his peen. So that's about it. Okay, let me go back to the other screen. But I thought that was interesting that they listed Love. That might be practice in Georgia. I've never seen I've never seen attorneys put other attorneys on the stand before. One moment. Let me get back to the right screen. Did I lose it? Okay, there we go.
Handle and stay very low.
All right, I'm just trying to find
Mr. Huey responded, SLAT, and for show.
I'm trying to find the civil forfeiture motion because that's actually what's relevant to at least tonight's discussion.
FASHO. I've been out the way and appreciate you for everything, my brother. Never about money with me. I'm built on loyalty. Mr. Williams responded, SLAT, handle that. I got.
What's her name? Love Talk.
After a posting was made by Mr. Watts picturing him, Mr. Shamel Drinks.
I mean, obviously, this is necessary for a plea. It's done in each and every um, case, and that's because the judge has to be satisfied that they just have to be satisfied that there are enough facts surrounding the plea that a defendant is entering into.
And
I'm
Mr.
just,
Jasper
I'm just generally tired of hearing love.
Walters.
You have to make sure there's a
On
sufficient
March
factual
14th,
basis for the plea.
2022, after YSL members spotted Mr. Drinks at a gas station. Mr. Drinks was gunned down as he drove away from the gas station and waited at a red light. Later, Mr. Stillwell, Mr. Nichols, Mr. Garlington, and Mr. Farley were all charged with the murder. That is one of the acts that we are still would anticipate the court seeing the evidence of during the course of this trial. After grand jury warrants were issued after this indictment for Mr. Williams and 27 other co-conspirators, following searches of phones, wiretaps, and other information that led police to understand the role that Mr. Williams played in the YSL street gang and enterprise. Mr. Williams' home, he was arrested at his home and a search warrant was executed inside his home. While at his home, a sale amounts of illegal narcotics, including those that he is charged with in this indictment, was found. Also found.
All right.
Was the machine gun with which the defendant has been charged in this indictment.
Okay, anything else of value?
The gun had a switch. The narcotics included marijuana, codeine, and cocaine. And inside the home were also other guns besides the guns with the switch. The items were seized, and again, Mr. Williams was subsequently arrested, along with other YSL members at Mr. Williams' home.
Anything else?
Your Honor, that is the evidence that I believe has been shown throughout the course of this trial and that the state would continue to show. There are several messages between Mr. Huey and Mr. Williams inside the cell phone one of the cell phones that were recovered from Mr. Huey. Besides the messages about tells Mr. Williams he has a new number.
Filings.
Mr. Huey asks Mr. Williams, hey, my brother, I'm fucked up. You ain't got nobody I can pull up on and have something in my pocket. Mr. Williams responds, slat, let me call BEO. Mr. Huey responding, slat, I need you, my brother. Mr. Huey saying, asking whether or not a lawyer was going to go and talk to another YSL associate, asking Mr. Williams to send him some money to pay his lawyer off. Mr. Williams asking Mr. Huey, who had been accused of armed robbery, what did he want? Mr. Huey responded with a number. Mr. Williams responded, slat.
God, man.
After Mr. Williams stole a star ring from one of the victims in the indictment, he asked Mr. Williams, do you have a star ring? Mr. Williams said, yes. Mr. Huey said, slat, you can't cash out me $500 so I can make a payment to my lawyer. Mr. Williams responded, slat. Mr. Huey sent him his phone number. Mr. Williams assured him through his responses, slat, that he would take care of them.
Because
I checked on that, Your Honor, with respect to
Uh-huh.
opportunity to make an impact statement. And that is all that we have. That the court sentence Mr. Williams, as we have asked earlier. And prior to the court imposing a sentence, we would ask that Ms. Shawana Edmonds, who is the mother of Mr. Thomas, be allowed an opportunity to make an impact statement. And that is all that we have, unless the court has questions.
Okay, well, given that Mr. Williams is not charged with the murder of Mr. Thomas, I don't think that that is applicable here.
I checked on that, Your Honor, with respect to count one. As a co-conspirator, Mr. Williams is responsible for all of the acts of the other co-conspirators, the overt acts.
And then
The overt
co-conspiracy.
act of the murder of Donovan Thomas is one of those acts.
I know, and this trial is not complete, and so y'all have not yet proven that. Not to mention that you dismissed the murder charge against one of the co-defendants who already fled. So,
Not
All
for
right.
that case, Your Honor. That was Mr. Drinks.
okay.
We have not dismissed any.
All right. Well, if there is a
No.
conviction on the RICO or murder count following the close of this trial, that would be the appropriate time for the victim impact statement to be made. All right, Mr. Steele or Mr. Adams, does the defense want to put anything on the record? Obviously, you need to make a recommendation.
Yes, Your Honor.
Go ahead.
Many of the statements made by the prosecutor, we vehemently disagree with.
Okay, I'm gonna forward to the judge. I just want to hear if there's any mention, or maybe is he gonna talk about the watch? I don't know. Maybe I should listen to all of it.
ON has the following information. The state only, because we haven't called witnesses yet. So the state put up a man
No,
who
I am
has-
forwarding. I'm sorry.
who said nothing except, I don't recall.
No.
It's fine. Fred Prethro's on my witness list as well as the detective, and I have the item, and he would have testified that Mr. Williams and they are high-fiving and laughing with each other. That is on audio video. There's a man who the state hasn't called yet, Mr. Martinez Arnold, also
All
known
right.
as Duke. It's on the state's witness list. He's represented by the Honorable Ashley Merchant. He's on that plane as well. He would have identified the item, and he would have testified that Mr. Williams and Mr. Lamar were very close in December 2014. Then on December 29th of 2014, Mr. Williams, Mr. Rich Omiquan, Mr. Arnold, others were at Brian Williams' home in Miami, Florida. There was a posting by Mr. Lamar, Rich Omiquan, and a picture of Mr. Arnold and Mr.
I need to forward.
Lamar.
I cannot do this.
You have an opportunity, verdict from the jury, and that's why he is tendering this plea. I'm telling the court this, and the court telephone analysis, known as Lil Wayne, to Mr. Bennett. In fact, the evidence, there was nothing to report on probation. Adopt that Exhibit A, but we can give it to the court.
Simply ask you. I join Mr. Steele and Mr. Williams in asking you to do the same. And I think you was
like these past 2 or 3 years of my life, I kind of learned that late, and maybe on both sides. I'm investing into this.
well in terms of conditions on Mr. Williams if we were to ever reach some sort of agreement. And we ask that if you feel that there is anything within the state's proposal that might be appropriate in terms of the sentence for Mr. Williams, that the court please feel free to do that. There is nothing that he puts himself before the court. And I think 2.5 years sitting, going through this process, challenging the process.
Well, I think I
but now
found
standing
it.
before you and asking
Did I find it?
that you consider everything and sentence him appropriately in the way
I
that we
guess I should
requested.
first confirm.
I'd simply ask you. I join Mr. Steele and Mr. Williams.
Hold on. I think I found the filing, but I'm not, maybe I should confirm.
And asking you to do the same. And I thank you as well, as
Um,
Mr. Steele did, for your patience with us and for
Working clerk,
bringing some order to the proceedings
10,
that candidly
clerk.
was needed. So
All
that's all I
right.
have to say. I thank you again, and I ask you to consider everything that's been put before you.
All right, Mr. Williams, is there anything that you want to say?
Yes, ma'am. I take full responsibility for, you know, my crimes or my charges.
Dang, I cannot see.
I want to say sorry to my family, my mom. My mom got 11 kids. I can't say all their names, you know.
Property.
Managers, my kids that's not here.
Property. See.
Really, everybody that got something to do with this situation, I want to say sorry for just like, you know, having so much time investing into this, you know, and I am a smart guy. I am a good guy, and I really got a good heart, you know.
No, I'm
I
listening
find
to the
myself
judge. Hold on.
and I did.
I don't want to listen to this again. Hold on.
By far the much of an impact.
You know, like free shows, and I always did that. You know, I did free shows and gave it to single parents, millions of dollars. You know, I made $1.8 million on a free show, and I gave it all to single parent charity.
Here's
I
June
did
14, 2022.
like 2 or 3 shows that made like $700,000 a piece, and I gave it to the breast cancer organization. Like, you know, I do things like I put millions of dollars back.
I just found one of them, but this is on my phone though. So how? Guess I'm gonna have to email it to myself. All right, hold on. Let me see if I can find it on.
I did more than anybody ever did from my side, you know. But I understand.
Yeah, there we go.
You know, rap lyrics. I understand how it could be twisted. I understand what it could do to the mind of people. I understand all that, and I promise you, I'm 100% changing that. You know, it's
Jeffrey Williams.
I'm older. I'm grown now. You know, and it's just like I'm smarter. It's more things to rap about. Like I've experienced a lot of good things. I experienced more bad things, but I experienced a lot of good things too. And anyway, I can go forever.
Well, I appreciate it, and I appreciate that you do realize how much of an impact you have on people. I mean, it's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living in and around that, you know that gangs are damaging to our community. And it may be that a whole lot of rap music and the rap industry is, I mean, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television, where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what is going on in the music industry with rap. But whether it is fake or not, it has tremendous impact on kids and young people who think this is cool. This is what I want to do. Look at him. He's a millionaire. I can do that by being, you know, a gangster in the streets. And that's not true. What you're likely to have happen to you if you're a gangster in the streets is you get shot, you get killed, or you get thrown in prison. And those are, you know, by far the most likely outcomes. And, you know, you've been in here watching the trial, and you've seen the pictures of
Fulton County,
Mr. Ryan posing with a gun as big as he is at 15 years old and going out and shooting and killing another teenager. And that's what gangs do. And that's unfortunately a lot of what rap music does. And if you are a modern day John Lennon, you know, I mean, he might have rapped too in this day and age. I don't know.
That's funny. I did not hear that.
And
I did not hear
even
that.
Even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the.
All right, I found the briefs. I guess I will let what's her name again? Paige Whitaker. I'll let her conclude, and then I'll get my glasses, and then we'll get to the motions that apply to civil forfeiture.
Powerful guy at the end of the street selling drugs. And, you know, I know that happens for protection sometimes, but A much better way would be getting an education and setting, hanging around with people who set a good example. And you be one of those people that sets a good example. I mean, all right, so that's my high horse on that. I could also go on.
Yeah, girl.
But I want
John
you
Lennon
to try
would have been a
to
rapper.
be
That's crazy.
more of the solution and less
Crazy
of the problem.
talk.
All right.
But then again, you never know.
All right. So it is not lost on the court that the state.
I mean, I watched this plea, but I was not thinking about it in the context of civil forfeiture. But usually, I mean, unless they do it very differently in Georgia, typically, but then again, the case is not concluded. Typically, at the time of plea, that is when, or at the very end, right? Before, let me think. Do we do it before sentencing? No. We do it after sentencing. So we might have to watch this until the very end. Typically after sentencing, that is when the prosecution asks for property that has been seized to be forfeited to the state. So that's where I guess we first have to establish that before moving on to the motions.
Had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count,
All right.
was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, machine gun count.
Honestly, I don't know.
Was willing to
What are they
give a
looking
sentence that permitted
What were they looking for?
Mr. Williams to walk out of the door today,
Right.
and therefore does not seem to be particularly worried that Mr. Williams, if on the streets, would be a danger to society.
Yeah.
I'm taking that into consideration and crafting my sentence. And in permitting a NOLO plea to the RICO count and one of the two gang counts, I would not be permitting the NOLO to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts, and for the remaining counts with which you are charged. I am going to impose.
NOLO, I don't know why that might be how they say it in Georgia, but I've always called it, or at least my jurisdictions have called it a NOLI. That is just a dismissal. It basically means that the prosecution is not pursuing the charges. They're dismissing. They don't want anything to do with it. And yeah, that's the gist of it.
Impose a sentence.
And I think that's once Jeffrey pled guilty, I think they should have ultimately dismissed the three remaining counts that relate to the firearms in his residence. I think that's what they should have done.
And I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution. On count one, the court sentence is 20 years to serve 5 years, commuted to time served.
I know we're going to have to talk a little bit about that probation, because for the life of me, I do not know. I don't actually know. I'm trying to figure out if I've met. It's rare for a criminal defendant that's on probation to not violate probation. It's just kind of rare because the conditions are often very strict, and I don't know. I personally don't even know if I could adhere to them. So
the balance of 15 years to be probated and a $25,000 fine. On count two, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count. It is required to be run consecutively. I'm going to run it consecutive to count one, but I am going to backload. Oh, I'm sorry. That is not commuted. That is 5 years to serve, and it's going to be run consecutively to count one, backloaded, by which I mean after you serve your 15 years of probation. If you have been successful on that probation, and I sincerely hope that you are, then at the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence, but I'm also going to impose a $15,000 fine with regard to that count.
Let me see how much.
Count 57, 20 years to serve 5, commuted to time served. The balance of 15 years probated, concurrent with count 1. Count 58, 10 years to serve 5, commuted to time served. Balance probated, concurrent with count 1. 59, 5 years to serve, commuted to time served, concurrent with count 1. 60, 5 years to serve, commuted to time served, concurrent with count 1. Count 61, 5 years to serve. That is required to be also a consecutive sentence. So that's going to be run consecutively to count 56 and backloaded. Count 62, 10 years to serve, also required to be served consecutively. That's going to be consecutive to count 61, also backloaded. So essentially, the total sentence is 40 years
Insane.
to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation, followed then by the backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful in completing your 15 years probation, that will be commuted to time served. You are to remain on reporting status for the first half of your probation, active reporting for the first 7.5 years of your probation, and that is
He's trying so hard not to
pursuant
smile.
to OCGA 17-10-1, subsection 2, I'm sorry, A2A. And Mr. Steele and Mr. Adams, in order to keep him on reporting status, there needs to be good cause shown. We all concede that good cause is shown here.
Stipulate.
All right, I appreciate that. Special conditions of your probation.
All right.
Good cause. What do you mean?
Can I have a second, Your Honor?
Sure.
Let the judge.
I need to hold on. I need to take on.
Thank you.
When was this?
All right. You had enough time to talk with your attorneys?
October 31st.
Yes.
Oh,
Okay.
that was right. That was Halloween.
All right, special conditions of your probation. After 48 hours from your release.
Okay, I don't want to deal with that. I just want to go to the very end to see if they talk about
And then also Sergio Kitchens as laundry detail or anybody that you're performing with. It's been challenging at certain times. That is fine with the court. And you may
Fine. What's
be
the exception
transferred to
to-
out of state, and that has to be done through probation, but that is fine with the court. And you may also keep your, nobody's mentioned it, but keep your passport and travel out of
That's
state
actually, I
and
like that
internationally to the
condition.
extent that you need to do that.
That's unrelated because I'm always going off on tangents, but I really like that condition. Okay, so I'm gonna pause right here. I'm gonna have to find what is it? The law and crime video, because that's, I guess we might have to consider the pleas for the 2 remaining defendants. But I want to switch my screen quickly. Let's go to the actual stop sharing. Let's go to the actual what is this? Let's go to the motions. Which one is it? Oh no, that print is so tiny. Okay, we'll start with 1 and then we'll take it from there. No, that's bond. That's not what we're looking for. Is this bond? Yeah, this is bond. That's not what we're looking for. Hold on. That's fine because it's one of these 2. Is it this? Okay, this is one of them, but this is kind of, I think these, let's see. Okay, this one is June 14, 2022. And this is, okay, let's start with June. So let me share the other screen. Let's start with June. I think this is June. Is this it? I need to increase. Hold on. We're gonna do that. Can I still see? Yeah. Okay. All right. So just let's touch base quickly. Okay. Just as a what is this? As a background or frame that we are going to work against. Okay. So it was. Let me put this properly. Let me put this in its proper form. So we're going back to 2022, and that's obviously we saw the raid. We're not going to rewatch that. So the law enforcement raided Young Thug's house. That was sometime, I want to say summer, or is that still considered spring? It doesn't matter. But that was 2022, right? And they forfeited from his residence. It was money, jewelry, guns, apparently a car. I don't remember a car. And then supposedly the amount of cash by itself was at least $150,000. Okay. And what happens is when a criminal defendant is arrested, let me give you an example. Let's say somebody is maybe an airport, because obviously people actually don't have at an airport or border, folks don't have the same rights as they would elsewhere, right? So let's say an individual is at an airport and they have, because usually at an airport you have to declare anything under, no, I think it's anything over $10,000 if I'm not mistaken. I can look that up, but I think it's usually, is it 10,000? I want to say it's 10,000. In any event, the amount itself does not matter because this is just a hypothetical. There's a specific amount that you have to declare at the airport. If you don't declare, and this is usually, it's more so international travel. I've not seen it happen with domestic flights, but international travel. As you leave the country or enter the country, you have to declare, you do have to declare goods. But if you have over a certain amount, I don't know, I really think it's over 10 grand, but I might be mistaken. At the airport, they are going to forfeit that money, okay? Especially if you've not declared it, you've not shown um where your money is from, and they suspect that it's from ill-gotten gains or whatever. They're going to forfeit that money. What that means is that they are going to take the money away from you. So that's not typically, no, it's not a good way of speaking. So when they raided Jeffrey's home, they forfeited the assets that law enforcement perceived to have been the what is this? That they perceive or thought he got through ill-gotten gains. Okay, and then let me see. Obviously, we know about the watch. Doug has reminded us about that watch every chance he got, and they seized apparently a whole bunch of other jewelry and things of that nature. Okay, so these folks were. When I say these folks, what I mean is the defendant in this case, Jeffrey, obviously at one point wanted his property back, or they pushed against the government. There's really a difference, because I want to say government, but government and state is not the same thing, even though I guess we do use the term synonymously sometimes, but it's not the same entity. So for civil and criminal forfeiture or asset forfeiture, it's basically an entity that is taking property away from an individual, and they are alleging that the property was obtained in contravention or violation of the law. That's what it basically means. For example, let's say you are found, I don't know what you'd be doing with a pound of cocaine or crack or whatever, but let's say that's what an individual is caught with. At the end of the day, you cannot, I mean, I'm sure somebody has tried, you cannot turn around and request this information back from the government. Once your case is done, they're probably going to destroy it, right? In this case, the case is not resolved though. So this YSL case is not resolved. And I would like to think that in order for the asset forfeiture aspect of this case to be resolved, I would like to think that that would only happen at the very end of the trial, at least as far, not the trial, both trials, like the one that's coming after as well, just because it's still, yeah, unless it's an item or an asset that relates to a specific defendant and is not part of this conspiracy, then that would be disposed of at the conclusion of that individual's case, be it through plea or conviction. But I guess it makes sense in who's this? In it makes sense that during Jeffrey's plea, the prosecution did not ask for asset forfeiture. I think they should have. They did not ask for asset forfeiture because the case was still ongoing and they did dismiss some of the counts. But let's quickly get into. Oh, this is the other thing I wanted to mention. For example, the supposed watch that what's his name? That Doug has been going on about. From my understanding, this was a gift and not necessarily something that Jeffrey purchased himself, or not something that can be said to he may have gotten through ill-gotten gains. And if that's in fact the case, then the individual who gifted him this, it does not necessarily have to be that individual, although they'd probably make a better witness. But if Jeffrey at the end, well, nobody knows where this watch is. I know I talk to myself a lot, but at the very end of the day, if him or his other co-defendants want the state to release these property back to them, it's a court proceedings, and they would basically have to show that these assets or properties, items, objects were not acquired through criminal activity or or they're not to be considered ill-gotten gains. So part of this, let's see, this is June 14, 2022. And this was, I need to increase this some more. Can I still see? Yeah, I think that's good. All right. So this was a motion filed, or actually it was an entrance of appearance. And then this pertained to property that was seized from Jeffrey Williams. And they're saying that this is the rightful property of somebody called Mr. Jacobs or Mr. Jacobs' company. Okay. And then you have an attorney that entered appearance. Actually, you do this. An entry of appearance is done in both criminal cases, civil cases, and even administrative cases. What I mean by administrative cases, that's a completely different branch of the law. It's something people don't really consider because you don't see much of it. But if somebody is, for example, getting on or going on social security, if it's a social security case, then you'd have to, and social security cases are neither civil nor criminal, they're just administrative cases. But you would have, an attorney does have to enter a notice. They call it entry of appearance. In my jurisdiction, it's called a notice of appearance. So you do that. And even for what's the department? There's a department that deals specifically with hold on. I want to say food stamps, but that's kind of minimizing what that's I'm just going to say food stamps, but that's that's not really what it is. Or labor law, for example, because that's part of what I do when folks are injured at work. I know I'm over explaining, so let's get on. So what they're claiming here is that this the owner, or Gabriel Jacobs is the name of the owner. Okay, they're saying that he is the owner of the jewelry that was seized by the state when Jeffrey Williams was arrested. Does that mean that they had loaned it to? I need to keep reading. Okay, so they're saying that during the arrest of Mr. Williams, the state seized numerous pieces of jewelry. Specifically, much of the jewelry seized belonged to Raffaello and Company, a New York jewelry store that specializes in custom. Does this mean he never paid the money? Oh, hold on. Now I'm just speculating because I'm trying to think. Have they loaned it to him or was it? I don't know. In any event, so they're saying the property is of substantial monetary value. Okay, being filed in order to advise the court that a separate judgment will be filed under the criminal case. Number can minimize any losses that. So basically, this is to protect. This is to protect what's his name again, Jacobs or somebody. Right. This is to protect Mr. Gabriel Jacobs and put the state on notice that in the event you do seek to go forward with a civil forfeiture process, this person has an interest in the matter, and they're saying that it's his property and it's not, in fact, Jeffrey's property. Okay, where are these people based out of? Oh, okay, Georgia. All right, so let's move on to the. Let's move on to the second. Let me actually close this so I don't end up sharing the wrong page again. All right, so let's move on to the second filing. All right, so I just need to, believe it or not, I actually have glasses on, but I still cannot see this print because it's just so tiny. Okay, so this one is from, all right, so this is December 9 of 2022. And this is the state's response. I need to find the original motion. Let me see if I can find. This is Fulton County. Okay, I'll read this, or we'll go over this, and then let's see if we can find the motion that the state was responding to. Maybe we probably don't even have to because they're probably going to address. Okay, this is for what's his name? Gabriel Jacobs. Okay, so the state of Georgia, blah, 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 Fannie Willis, blah, 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 on June 17, 2022 and June 21st. So they're saying Williams and Raffaello and company filed motions for return of property seized from Williams' home after his arrest on indictment number, the previous indictment of the present case. The motions filed by Williams and Raffaello and company for the return of property were filed in June, blah, 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 blah. I'm not going to go through all of that. Okay, so they're saying that they were filed before the Fulton County District Attorney's Office instituted or filed a civil action for forfeiture of the seized property. Any continued request for the return is properly addressed in the accompanying. Okay, they better have this here. So I'm going to copy that because we're going to find it on the what's the Fulton County Clerk's Office or their website. The court record shows that the civil forfeiture case is stayed pending resolution of the instant matter. So yeah, that's what I figured because I'm just reading this stuff. I mean, if you were here from the very beginning, I was searching for these things as we're going along. But that's what I figured, that the state would, or the cases would first have to be resolved before they can even do much with this. Otherwise, it's premature. So it's going to be, I hope the second case does not take as long as this case. But in the event that it does, it's probably going to be another year before they can have a resolution as to the assets that were seized out of who's this? Jeffrey's home. Oh, so these two folks actually work independently. All right, now I'm so nosy. I'm probably going to look them up, but I'll do that. I'll do that after the fact. I still want to take a look at. Hold on. I still want to find. I want to find one of the other civil forfeiture motions, but while we're doing that, let's go back to the proceedings of October 31st. Hold on. Where's this? Okay, it says watch again. So let's go back to the proceedings of October 31st. And the reason why we are doing that is because I just want to, I mean, obviously, we've debated a lot as to what was on the table or the offers that were extended to the two defendants in this case. Because if I remember correctly, I was of the opinion that the plea offer for Shannon was 40 years, but Allie had remembered Yak getting a harsher offer. So I don't know. Let's go into that while I search for the other motions. One moment. We're gonna have to find October 31st. I don't even remember what day was that. Hold on. It's easier if I just do this. What's his name? Jeffrey. Jeffrey Williams. And I watched Star. I watched Star earlier around, let me see. This was around, he was live around, I want to say maybe 8 p.m. Does that sound? No, it must have been 9 p.m. Star was live. He was talking about what's that man talk? Some case out of, I believe it's out of Georgia or something to do with content creators and a person vanishing and things of that nature. But all right, so let's see. Jeffrey Williams' plea. What day was that? Was it 154? Yep, 154. So let's see. What is this? Is it a month ago? No. No. Hold on. I cannot see. So it's further up. 51. Then we have Melody Ferris. To, I think this is it. Is this it? Yeah.
Day.
So, oh my goodness, all these ads.
Why aren't they texting me back?
So we're not gonna go through. We're not gonna go through all of this because obviously we've watched. Why are they crying? That's funny. That's funny. All right, come on. We want to go back to here. All right, because we have Jesse Weber. No, this is not. There we go. I was about to say what? All right, come on. All right, I'm going to find the other filing while we are. Am I sharing the right screen? Yes, I am.
Imprisonment. He's charged with count 57.
And I'll put my link in here if anybody has questions. I don't know if Allie's here or not, but I do have some answers. There we go. I do have some answers regarding what was that? Let me go back. This is from 2 or 3 nights ago. I do have some answers regarding, I believe it was the conspiracy. Was it the conspiracy? I believe so. All right, let me play this. I'm gonna go back to the Fulton County clerk's website. That's kind of
which is
loud.
participation in criminal street gang activity, which carries a sentence of.
Hold on. I'll just turn that down.
Imprisonment. He's charged with count 57, which was participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He was also charged with count 58, which is violation of the Georgia Controlled Substance Act. That is for the possession.
Right, marijuana.
Of marijuana, which carries a sentence of 1 to 10 years. As to count 59, I believe that's the possession of codeine with the intent to distribute, which is 1 to 5, which is 5 to 30 years. And count 59, which is the possession of cocaine, which is
60 is possession of cocaine.
So 59 was the codeine, 60 is the possession of cocaine, which was 1 to 5 years. Possession of a firearm during the commission of a felony, which was count 61, which is 5 years to serve consecutive to any count indictment.
Mhm.
Possession of a machine gun, which was count 62, which was 10 years to serve consecutive. And then he was charged with count 63, which is possession of a firearm by a convicted felon pursuant to 1611-133. I know my math isn't the best, but that's life plus some years. The state's recommendation, Your Honor, was for Mr. Kendrick to plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which was 20 to serve 15. Count 2, the murder reduced to voluntary manslaughter, 20 years to serve 15. 20 years to serve 15. And then to the gang count 57, also 20 years to serve 15, all to run concurrent, and the state was willing to null pros all the other counts in the indictment.
All right. And Mr. Kendrick and the attorneys associated with you, I want to make sure that y'all know that unlike what happened with Mr. Williams, if you plead non-negotiated to less than all of the charges, there is nothing that the court can do if the state chooses to go forward with some of those charges. So you could not do what Mr. Williams pled guilty or nolo to each of the charges that he was facing. You cannot say, well, I'd like to plead guilty to count 1 and I'd like to plead to the reduced charge on count 2. And then I'd like to just skip the rest of them, because the state can say, well, we're not skipping the rest of them. We're still going to try you for the rest of them. And the state can also say, we're not okay with letting you plead to voluntary manslaughter unless you abide by the terms of the agreement. We're going to go forward with the murder trial. So I know that Mr. Weinstein, you and Mr. Apt and everybody else who's been helping know that, but because things seem to have worked out sort of beneficially for some of these other people who have already pled, y'all might think, oh, well, gosh, can't we do something better than that? Given what you're facing, they hold a lot of the cards, and a lot of it is outside of the ability of this court
discretion
to change. Okay. All right.
We understand that, Your Honor. Thank you for advising us of that.
All right. Mr. Stillwell is facing.
Your Honor, Mr. Stillwell is also looking at count 1, which the conspiracy.
I mean, that's never mind. I was gonna say something else. Let me let it go.
To violate the Racketeer Influence and Corrupt Organizations Act, which is 5 to 20 years. He is facing 2 counts of murder for count 2 and count 49.
Somebody said, what's his name? Gotti's cooked. I don't know. People say a whole lot of stuff. Okay, for some reason they're calling him a rat. And of things. All right.
Which each carries a sentence of life imprisonment. He's also charged with count.
Okay, so somebody else said, yeah, they don't know, but Shannon is, I guess wasted. That's how I'll put it. Okay, we'll get back to the evidence. I'm all over the place. Let me let this woman talk.
Of this indictment, Your Honor, which is participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He's also charged with count 51, participation in criminal street gang activity, also a sentence of 5 to 20 years. Count 52, possession of a firearm by a convicted felon, previously convicted under 1611-133, which is 15 years consecutive to any count in the indictment. 54, possession of a firearm during the commission of a felony, which is 5 years to serve.
Okay, so all right, I'm distracted. Hold
consecutive count. And count 64, which is another possession of a firearm by a convicted felon under 1611-133, which is also
really
15 years to serve consecutive. So Mr. Stillwell's looking at maximum of 2 life sentences plus 20
85 years.
plus 85 years, Your
insane.
Honor. The state's recommendation, and I'll just say globally, Your Honor, was 60 years to serve 40 years in prison.
That's
That
insane.
we would have reduced both of the murders to voluntary manslaughter, Your Honor. And we
Okay.
had given his attorney the option to kind of craft how that 40 years would
That's
look.
insane.
But
Okay.
that was the extent to our
right.
negotiations, Your Honor.
I don't know. I don't know if it's nerve or
And
something.
Mr. Stillwell, kind of the same information to you. If the state does not want to reduce charges, you're not entitled to plead to reduce charges. They can say, you got to face these murder charges and we're going to make it a jury trial if you don't agree to what we're offering. Same thing, you can't say, well, I'd like those other charges dismissed if they're not willing to dismiss them in exchange for the negotiated sentence. So obviously, each of you has the right to continue with the trial.
No, did I miss Yax? Did I miss his plea offer? Because I don't recall them saying anything unless it was just not on camera.
What you're
Or maybe
doing,
they weren't
you are
trolling.
all have very capable attorneys representing you who clearly care very passionately about you all
Right.
personally, as well as presenting your best case. But it's ultimately going to be up to the jury. And you cannot know what any jury is going to do.
Right.
And they may say, I don't believe a single bit of this beyond a reasonable doubt. Y'all are both welcome. They may say, you know what, I buy this, I don't buy that. I'm convicting you of 4 of the 5 or 4 of the 8 charges. You're still then going to face sentencing. They may convict you of everything. And if you are convicted of everything, Mr. Stillwell, you're facing 2 life sentences plus 85 years on top of that, as opposed to
I'm sure that's harsh
40 years to serve
punishment, even though the
with parole
Supreme
as a
Court disagrees.
possibility.
But
And Mr. Kendrick, you're facing life plus, I think I added up 115 years
how's that even?
instead of
Nobody lives that
20
long.
to serve 15. So it's
Instead of
just
what? Hold on.
some reasonable doubt. Y'all are both welcome. They may say, you know what, I buy this, I don't buy that. I'm convicting you of 4 of the 5 or 4 of the 8 charges. You're still then going to face sentencing. They may convict you of every.
Somebody said SB should have taken the plea deal before Nichols did.
Everything.
I guess
And-
we might as well go through some of these the plea material. That's what we're gonna do. I first have to explain something though, but that's what we're gonna do.
If
after
you are
this.
convicted of everything, Mr. Stillwell, you're facing 2 life sentences plus 85 years on top of that, as opposed to 40 years to serve with parole as a possibility. And Mr. Kendrick, you are facing life plus, I think I added up 115 years instead of 20 to serve
I keep
15.
going
So
over.
it's
I'm sorry, I'm distracted. Okay, this is the this is the last time that I'm going back because I got distracted. I started looking at something else.
still then going to face sentencing. They may convict you of everything. And if you are convicted of everything, Mr. Stillwell, you're facing 2 life sentences plus 85 years on top of that, as opposed to 40.
And I think that's what this is. The penalty that's hanging over SB's head is the reason why I still have a hard time. I have a hard time believing. I mean, obviously, the marriage license is out there, but it's puzzling to me because it doesn't make sense. If somebody is potential, it's different. Listen, if I don't know, that's even very tricky. It's inconceivable to me that a criminal defense attorney that has had enough context with the criminal courts or criminal justice system would voluntarily get married to a man that's on trial and is facing a steep penalty with a possibility, unless they just know that this man is getting acquitted, it does not make sense. There has to be more to this, but I'm gonna let that go because I don't feel like being gossipy tonight. Okay, tonight I'm not gossiping. I'm just sticking to the law.
Years to serve with parole as a possibility. And Mr. Kendrick, you are facing life plus, I think I added up 115 years instead of 20 to serve 15.
Right. That is exactly how I remembered the plea offer to go. Because from what I recall is that the sentencing recommendation from the state had more to do with a number of Merck charges that the defendants were facing. But at least we've
So it's just something to think about. And I mean, it's already past 5 o'clock. So are y'all going to leave the offer open until you have withdrawn
That girl is trying to go home. She has vacation plans.
on the offer before you even put it on the record to?
We communicated this to them last night, but they did not accept it. Then we would have withdrawn off.
All right, well, given that the state spent the entire day negotiating Mr. Williams' plea, ultimately unsuccessfully, I don't know if either Mr. Weinstein or Mr. Sharp would have been able to negotiate with you during today.
Yeah, you can tell. To me at least, it seems that she wanted these cases resolved through pleas.
Although we didn't have any communication from Mr. Weinstein or Mr. And they rejected the offer.
Okay.
I did have communication with Mr. Abate today. I attempted to have
All right.
communications with the DA last Tuesday
Well,
morning, but she failed to show
Well,
up
it sounds like they all wanted to resolve through pleas anyway.
for
So,
our meeting.
Any chance y'all might leave it open until 9 o'clock tomorrow?
but I was actually I was shocked that they did not. Oh, I should need to stop using they them pronouns. I just need to. Okay. In any event, I was shocked that the prosecution. I'm just shocked that they had not extended the pleas for a longer period of time. But I mean, the offers 40 in comparison to 2 life sentences. I guess it sounds reasonable if you look at it from that perspective. But nobody lives that long. Okay, people do not live to 100 years. I think that if the offers had been probably less time, I do not doubt that the defendants would have accepted them.
Your Honor, I'll consult with the DA and if she wishes to read.
Okay. I mean, I have no idea whether they'd want to keep it, but I haven't, we haven't put it on the record and I haven't ensured myself as the court that they understood what the potential sentences were up until just now. So I would appreciate it if she would, so that they have the opportunity, having heard from the court, to talk to their attorneys. And they may still say that we're good, we're going forward, but.
Right.
We'll consult with the district attorney, but as a.
Okay. So in the event that it is no longer open to you or that you decide to reject it anyway, I plan to start the trial again Monday morning.
All right.
I'm going to have the jury be here at 9. I'm going to have us be here at 8:30. We're back to getting no sleep. So,
all right, let's go back to, because we just wanted to get that out of the way. Let's see. I've not found. I think I cannot find another civil forfeiture motion on the clerk's website unless I'm just not looking. I mean, but it does go all the way to 472 tabs. Okay, so we're not, hold on. All right, we're not doing that. So let me stop sharing this screen. Hey, Northern Dame, what's up? So let me stop sharing this screen. Now I wanted to get into, I was looking at, what is this? Forensic medicine. I was going back to, what was that? What was that? My brain is fried again tonight, y'all. I was working in the hopes that I don't have to work over Thanksgiving, but I might have to work over Thanksgiving because I have a deadline coming up and I'm not done with that. But I wanted to take a closer look at, what is this? Gunpowder residue. And I was going over my forensic medicine material here, but I don't know. It's a lot to get into. In the meantime, though, let me answer. I'm gonna answer a few questions because I'm gonna have to pull up one of the older lives, right, from this past week. Um, I think I remember Ellie's questions, but there was somebody else. Hold on, I'm just gonna have to pull it up. Hold on. Let's go to YouTube. Let's go to YouTube. And Jerome, if you are in here, I have something for you. Okay. Am I sharing the right page? Hold on. Let's go to YouTube. Let's go to my channel for a moment because I want to. There was a question somewhere in there from what day is it today? Today's Saturday. I want to say from Thursday. Hold on. That was a question in one of these lives. I cannot find it. So let me just, I mean, I kind of did not look for it. I did not play the video. Let me just answer some of Ellie's questions. Let me look at the timestamp here. Okay, so it's one, hold on. Let me write this down. But I'll send it to her, let her know where to find her answer. So 136 about. Okay, so when was this? A few days ago, as we were discussing Rico, no, I think it's when they were dealing, when the court was dealing with, when the court was dealing with the jury instructions or the jury charge. Ellie had not asked the questions in detail because we were pressed for time, but I would like to assume that she wanted to understand predicate, what a predicate offense is, as well as an overt act in criminal law. And Ellie, when you do listen to this, if this is not what you're going to ask, then you can certainly re-ask your question. Okay. So as far as, because these are really the building blocks of the charges that SB and what's his name and Gotti are facing this, or at least in this trial, right? So an overt act basically means that an act or action conduct that demonstrate a person's intent to commit a crime or be part of a conspiracy. What that means is that basically thinking about committing a crime or thinking about being part of a conspiracy or even just talking about it is not really enough. There has to be some outward conduct in order to meet some of the essentials as far as a conspiracy or crime is concerned. So let me see if I can come up with an example. Let me see if I can. Okay, so if folks, this is actually a good example. Let's say, I'm telling myself it's a good example. So let's say that the folks in this YSL trial came together. They discussed at length about how to, or let's say if we go back to the gas station, right? Let's go back to that BP gas station. If we say that Nichols and SB and the other folks that were in the second vehicle came to some sort of agreement in I mean, it's still puzzling to me. Hold on, I need to finish one thought. If we're going back to the drinks charge, I still do not know the identity of the individual that was in the white shirt that Drinks what was talking to prior to exiting the. I mean, we could probably find this, but we don't want to go down another rabbit hole. We, anyways, we don't know what the discussion was about. But let's say this individual ended up having a conversation with his friends or associates, right? A conversation alone is not enough. There has to be outward conduct um, in order for the defendant's conduct to in order for them to basically satisfy the element of an overt act. Okay. One of those things, for example, would be them driving behind drinks, right? Another one would be, for example, retrieving a firearm, something of that nature. But defendants or suspects or individuals just coming to an agreement about something is not sufficient for conspiracy. There has to be some outward conduct in order to satisfy at least part of the conspiracy. Okay, so you have to do something more. I mean, even driving the car, driving behind him, um, following him. Scouting him out, waiting for him, laying in wait, things of that nature. Okay. And then the other question I believe she had, like I said, she did not really complete her question because we were pressed for time. But it's this whole thing of what a predicate offense is as it relates to the RICO. This is really conspiracy, and that is what I'm not going to say that's what makes it dangerous because conspiracy is really just, I'm going to keep saying this again. Conspiracy, the charge itself is a tool that prosecution uses because it's easy for them to satisfy, um, it's easy for them to prove up. For example, a conspiracy to commit murder is easier to prove. Excuse me, my throat. A conspiracy to commit murder is easier to prove than a murder itself. Okay, if that makes sense. If it doesn't make sense, uh, ask a question. Okay. Where were we? Because I'm all over the place. So basically, as far as the Racketeering Act is concerned, there are certain offenses, okay, that constitute racketeering. And there it's a whole bunch, it's a whole list. And actually, here is a very interesting point. You won't hear about this. I mean, I do gossip a little bit, but I gossip a little bit. I gossip a little bit, but you also do find out about the law here. And you're not gonna know or hear about this from channels that strictly gossip. But at the federal level, there isn't really a Merck charge. I mean, I'm not saying that they don't take on cases where folks have passed or have been taken out or deleted. But as far as a lone standing charge, that is not a thing, or it's not a charge, or it's not criminal no, I cannot say it's not criminal conduct. It's criminal conduct, but there's no lone standing charge of Merck at the federal level. But some of the offenses that could be tied into a RICO or a predicate act is basically drug dealing, bribery, arson, kidnapping. You have to do for a RICO, you have to engage in some other conduct or some other act in furtherance of whatever your organization is. Okay. So that's really what it is. It's not sufficient, for example, for the prosecution, it is not sufficient for them to basically print out an indictment. Not really, it's more complicated than that because depending on the state, though, not every state has a grand jury. I've worked I really worked in 3 jurisdictions, and my current jurisdiction, there's no grand jury. Grand juries do not exist here. So I mean, that kind of gives you a hint as far as location is concerned, but we do not have grand juries. Um, so it is not sufficient for the prosecution to indict a defendant with a RICO proving without proving a predicate act, basically, or an offense under that they were carrying out, or the defendants. I need to stop saying they, he, him. Um, okay, now I'm just rambling. Hold on. And then I wanted to talk a little bit about there's a 10-year bar on prior criminal conduct. So we will get into that shortly. But I wanted to see if I can find. Hold on. Let's get back to these YouTube streets. I wanted to see if I can find. Hold on. This is one. No, that's not what I'm looking for. Hold on. I'm gonna stop. No, I'm gonna share my screen. You guys can listen to this while I find. I'm gonna listen to this. No, actually, we're not doing this one. You can continue with short while I find the video that is of significance to this topic. We'll carry on here and then I'll be back. Not an ad. Oh, okay. Is it an ad? Showing a whole bunch of cars. I'm gonna get into some really ignorant stuff. What time is it? All right, it's 11:48. I'm still good on time. I'm good on time. So after we're done, I just want to make sure because I wanted to address gunpowder residue. I cannot find the chapter, but I'm gonna have to get up quickly. I need to go find my criminal procedure book. One moment.
On count 1, on this indictment, the state charges Shannon Stillwell with conspiracy to violate the RICO Act. They say on or between January 24, 2013, and the 8th day of May 2022, he and others unlawfully conspired to acquire, maintain directly and indirectly an interest in and control of United States currency and other personal property through a pattern of racketeering.
All right, hold on.
The state in their opening said, further the interests of YSL, further their goals.
What is
They
he gonna
also
say?
said they endeavored to do a lot of stuff
Our criminal
to get them a lot
procedure.
of stuff. Okay, it's a little bit more complicated. In RICO, the actions need to be part of a racketeering organization, not a drug dealer selling drugs to put food on his own table. So for his studio time to chase his.
I mean, we listened to part of this. I hate that I cannot actually watch. I cannot watch closing or at least I cannot react live to them. But I also cannot watch them in the entirety because I have clients coming in on Monday. In any event, Short's argument about SB selling drugs to, I suppose, feed his family, that is only going to fly with people that have, at least people that have had some contact again with the criminal justice system. And the reason I say that, it's because it is one thing to claim that your client stole, I don't know, a can of beans or whatever to feed their kids, or a client stole a bag of Pampers or a box of Pampers. But it's another if your argument is that they had to sell drugs in order to put food on the family. to put food on the table for their families. So that argument really, I don't know. You'd probably have to be somebody like me to think that that's, some type of justifiable conduct or excusable conduct.
It's a wrap. I'm going to ask you, as closing evidence, to find Shannon Stillwell not guilty, count one. Okay. The other color, besides dollar bill green and I guess bill bud green that I'd like to talk about is Fulton County blue. Now, Fulton County blue refers to the Fulton County Jail, 901 Rice Street, where people are taken when they're arrested for felony charges in Fulton County. And Fulton County blue refers to the jumpsuits that these individuals wear, the county issued jumpsuits that are typically navy blue, but deep navy blue, it's a Fulton County inmate on the back. You'll hear about the conditions of jail life and Fulton County jail life in particular, and common sense dictates some of this. You're confined to a cell, sometimes with another man sharing that small
Oh,
cell.
I know. I just remembered one of the questions. Let me take down the time again. Hold on, I'm gonna take down this time for Ali. I remembered one of the questions that she asked 2 days ago as well. It was, hold on, now it just escaped me. Hold on. I forgot. I forgot. I just had it. All right, I'll be back.
You have no privacy. Use the bathroom in front of men, shower in front of men. You're in fear, danger. You're separated from your family.
I remembered. She had asked about a what is this? A statute of limitations as far, because again, this discussion was surrounding it was surrounding jury charge or the framing of jury instructions, right? So that's what was happening this past week. So I think, okay, from my perspective, a statute of limitation is kind of maybe it's not self-explanatory for a lay individual, but for a lot of crimes, with the exception of Merck, there might be some other exceptions depending on the state as it relates to R. You see, now I'm going to go down another history lesson. I'm trying to figure out, there's a state, I cannot remember, because this really stems from a case. Again, most of the laws we have are framed by case law. You see, I'm really supposed to be answering the question, but now I'm okay. Let me put it this way. A lot of crimes have statute of limitations. You have to bring, the prosecution has to bring the charges within a certain time frame. If they decide to bring the charges after the statute of limitations has expired, then they have no authority to bring the case or the charges. The same applies in the civil context, but in the sense that let's say, for example, in a car crash, right? When somebody is involved in a car crash, this is, I'm just going to be, because I wanted to say tortfeasor, but I don't want to confuse anybody any further. Okay. So two individuals are involved in a car crash. The victim in that case, the individual that was not at fault in that case, has 3 years. Again, depending on the jurisdiction, in my jurisdiction, it's 3 years. That individual has 3 years within which to commence a lawsuit or commence a proceeding against the tortfeasor, who's the wrongdoer, the person that basically crashed into them, right? If they don't bring a claim within 3 years, then they have no right of recovery as it relates to that car crash. So that's what statute of limitations are. You have to bring the charges within a certain period. If it's a civil case, you have to file a complaint before the statute of limitations expire. And I'm just going to go off on a tangent here. I'm just gonna give you more information than you really need. But for example, in a in what is this? In car crash cases, okay? Most of these cases really do not go to court. Again, it's plea dealing, it's settlement. So in the civil context, a lot of these cases settle through settlement. It is unless you're just really incompetent. Otherwise, it's rare to blow a statute of limitations claim. And if it's really close, if you see that, or if an attorney sees that a client or a potential client wants to retain them, but it's too close to statute of limitations, you kind of really have to rush to file the claim. And why I'm saying that this is that once you file the claim, then the case can pretty much take as long as it takes. But in order to get into civil court, you have to file that claim before the statute of limitations is up. So in the context of this RICO case, this YSL trial, the defense attorneys were arguing that, I mean, obviously, these individuals have engaged in, or it's alleged that they've engaged in a number of criminal conduct, or in several criminal conduct. But the dispute was that the defense attorneys did not want the jury to be instructed regarding predicate acts or predicate conduct that their clients engaged in where the statute of limitations has already expired. And I believe they were not charged for, but that's neither here nor there. But that's what the argument was. They're saying if the prosecution is out of time and they cannot legally bring these charges against the defendant, it does not make sense for the the jury to be advised of conduct that the prosecution would not even be able to bring against the criminal defendant. Anyways, that was just me remembering what I know. Sometimes as I go through the day, I'm just thinking about all these random questions that have popped up in this case and how it has. I mean, it's really Kayla and SB that have consumed. I mean, Taisha too. They live rent free in my head. But anyways, let's get back into this. Let's get back into this. I'll come back with I was going through my criminal procedure book because I remember, I think this was a question from Ali as well, unless I'm mistaken. Anyways, let me play this and then we come back.
Loved ones, but most importantly, the men wearing blue, Fulton County blue, they've lost control of their lives. They've lost control of their destiny. Their destiny is now in the hands of the judicial system, in the hands of prosecutors. Ladies and gentlemen, Fulton County blue is going to be a very important color in this case because the state's key witnesses in this case that they're going to call to testify, that I anticipate that they will call to testify against my client Shannon Stillwell, when they became involved in this case, they were all aware.
Oh, this is random. This is more information, by the way, as it relates to. Should I give you this information? No, this is too much information because it does not even relate to criminal cases or civil cases. I mean, maybe civil to a certain extent because it is workers' compensation. By workers' compensation, it's not really a common law remedy. I'm not going to overwhelm you guys with a lot of information. So let's listen to Shard.
Fulton County blue. When Darius Zachary, Kenneth Copeland, Sammy Davis, Tremont Stillwell, Spencer Wright will hear them testify if they're called. You'll hear what they've said previously, perhaps. But what you should keep in mind is, when did these men say what they have to say? Did they say it when they first got the information to share? Or when they claim they first got the information to share? Or did they share it when they found themselves wearing the Fulton County blue? When they no longer had control of their destiny?
That's actually a good theme.
Needs, and they needed a favor.
Oakland County Blue.
Once upon a time, there lived some lovers of fashion
I get
in a
so
land where
mad.
good taste was king.
No, I'm not mad.
And they decided to insert themselves into a high-profile case that could solve all their problems. Okay. Let's talk about January 10th, 2015. That's the case involving Mr. Thomas.
And again, you know, when you're on here, I definitely have to distinguish between factual truth and substantive truth. And I'm just going back to what is this? We're going back to the statute of limitations in this case. Okay. Again, if we go by factual truth, it's the fact that SB engaged in XYZ conduct. But if we're going by substantive truth, then you know that because the statute of limitations has bar and the prosecution cannot bring those charges, then it really does not matter. And that's why I like to distinguish between the two, because oftentimes people think that, or at least in the context of a criminal case, folks think that just because somebody has, in fact and in truth, engaged in certain conduct, then that's all that matters. But again, when it comes to criminal law, we're governed by criminal procedure as well as the law of evidence. And that, or at least those two branches, because you have criminal law, which is, again, I'm giving you guys more information than you need. But criminal law, that's basically where you find the different elements of a crime. And then you find the specific, what I mean by different elements, it's actus reus, mens res, causation, okay? That's where you find criminal law, okay? And then for criminal procedure is all these 403, no, that's evidence. That's where you find these rules of evidence, 403, 609B. That's where you, when somebody objects, hearsay, sustained, overruled, that's all the law of evidence. And then procedure, if you're trying to, let me see. Yeah, I'm definitely giving you guys more information than you need or are going to use. I mean, this is not legal advice, so I'm just talking. This is just legal commentary.
And the evidence will show that this was a high-profile case. And the reason, and this is not me talking. I anticipate the evidence will show. I anticipate the state's own witnesses, the state's own gang investigators will tell you, not me talking. I anticipate they will tell you that Donovan Thomas was a big deal, that he was a gang leader, that he was a leader of the Inglewood family Bloods in Atlanta.
Let me see. Okay, I was gonna say something. Never mind.
That he was high ranking. And that's what made this case a big deal on the streets. You'll also hear that this case, the shooting of Donovan Thomas, was caught on surveillance video. Now, I'm not going to suggest that it's the highest quality surveillance video, but it was caught on surveillance video. And you'll be able to watch the surveillance video. And you'll see McDaniel Street in downtown Atlanta at about 7:20 p.m. on January 10, 2015. Remember, winter, it's cold, dark. And you'll see a car zoom down McDaniel Street towards Northside Drive, headed northwest, I believe. And you'll see and you will hear testimony that Mr. Thomas was with other individuals. What they were doing, I don't know, but he was with other individuals in a parking lot in between two barbershops, one being Mr. George's barbershop and one being Mr. Bernard's barbershop. And you will hear that this car zoomed down this dark street on that January 9th And it appears from the video that you will see that an individual starts shooting out of the sunroof in the direction of Donovan Thomas and others. And you'll see that surveillance video for what it is and what it isn't. And you will also see how quickly everything occurred that night. A matter of seconds.
Parents, are you doing enough to get your child into a top university? Do you worry whether or not you're doing?
Detective Thorpe is the Atlanta Police Department detective that was assigned this case in January 2015. And you'll hear that he gathered the evidence from the crime scene.
All right.
There was no DNA. There was no fingerprints of value. You'll hear that there were shell casings all along the street, but you won't ever hear that these shell casings were linked to any particular gun or Shannon Stillwell or anything else. And there were no eyewitnesses on January 10, 2015 coming forward saying, yes, I was here and this is what I saw. And I saw this person do this. There was none of that. And you'll hear that this case remained unsolved. No one had been charged for 9 months and 9 days.
All right.
On October 19, 2015, 9 months and 9 days after the Donovan Thomas shooting, a man named Nicholas Robinson was arrested on the streets of Atlanta and brought to Fulton County Jail for various pending charges. And you will hear evidence that Mr. Robinson decided he needed help. He didn't want to wear the Fulton County blue. You will hear that he contacted.
I mean, we're gonna take a closer look at the some of the lyrics, or at least the lyrics to the songs that the prosecution introduced in this case in attempting to prove the case or the charges against these defendants. But I don't think we're gonna get into that tonight. I mean, it's still kind of early. It's like 12:09. Let me think about it. Hold on. Let me think about it.
The Atlanta Police Department and got in touch with Detective Thorpe. And Detective Thorpe came out and interviewed this Nicholas Robinson. You'll hear what Nicholas Robinson said in this interview, how he gave his vantage point to Detective Thorpe, how Nicholas Robinson said that he was seated at the MARTA bus bench right across McDaniel Street from the barber shops. And you'll hear that Nicholas Robinson told Detective Thorpe that he saw it all, and he saw the people that were inside the car, and he gave names. Nicholas Robinson said, I saw Antonio Sledge. He came out of the sunroof shooting. I saw Kenneth Copeland. He was in the front passenger seat. I saw Demetrion Garlington. He was the driver of this car. Quindarius Zachary, he wasn't there, but he supplied the gun to Antonio Sledge. And yes, I saw Shannon Stillwell, my client, in the back, passenger side, shooting a handgun. So Detective Thorpe, after taking this information from Nicholas Robinson, who just broke the case, created photo lineups. And you'll learn what a photo lineup is. It's essentially 6 photos that contain a picture of a suspect and then 5 what we call fillers. And you'll learn about that. And Detective Thorpe showed these photo lineups. A photo lineup with Antonio Sledge, and then a photo lineup with Kenneth Copeland. Each person had their own photo lineup just to ensure that Nicholas Robinson could pick these people out of a photo lineup. And Nicholas Robinson did. And he signed his name, Nicholas Robinson, next to the picture of Antonio Sledge, and next to the picture of Kenneth Copeland, and next to the picture of Demetrion Garlington, and next to the picture of my client, Shannon Stillwell. Nicholas Robinson signed his name and said, these were the people in the car. Ladies and gentlemen, why am I telling you this? Well, Detective Thorpe had two small problems. First, you will see the surveillance video. You will be able to watch the surveillance video and the lighting conditions out there and the fact that there's gunfire going every which way and how fast the car is moving. And you will be able to judge, was it ever even believable that someone could see 4 people inside a car under those conditions? But there was a bigger problem that Detective Thorpe had. You see, you'll learn that during this interview with Nicholas Robinson, it wasn't only Detective Thorpe, there was another investigator there, an investigator Gaither. And while Detective Thorpe was talking to Nicholas Robinson, Detective Gaither was doing some investigation of her own and looking into Nicholas Robinson and who this guy was who had just been arrested. And after Nicholas Robinson picked out all these people, including my client, Detective Gaither had to tell Detective Thorpe a little secret. Detective Gaither had to tell Detective Thorpe, that guy in there just signed those photo lineups that just signed their case, his name isn't really Nicholas Robinson. He lied to us about his name. His name is actually Spencer Wright.
This guy's so dramatic.
So, the case was solved by someone who lied about their name. So, what was Detective Thorpe's solution? Well, this is what the evidence would show. Detective Thorpe completely overlooked the lie about the improbability of a man spotting 4 different individuals in the car moving at a high rate of speed in the middle of the night. He overlooked those things. And he said to Nicholas Robinson, or said to Spencer Wright, yeah, I've come to learn that your name is not actually Nicholas Robinson, it's Spencer Wright. Could you look at these photo lineups again? And instead of writing a fake name, Nicholas Robinson, could you actually sign that your real name is Spencer Wright? And Spencer Wright did. So what happened? Detective Thorpe on October 19th, 2015, based on the word of Spencer Wright, the man who had just claimed to be Nicholas Robinson, Detective Thorpe took out warrants for Antonio Sledge, Demekion Garlington, Kenneth Copeland, and my client, Shannon Stillwell.
When I first joined Honeybook, I was roughly making $1,500 a month. Fast.
Good for you. All right, so let's quickly talk about because today's what? I know I keep saying that a lot. No, it's actually not Saturday, it's Sunday. Let's quickly go because we talked a little bit about the conspiracy. And I don't know, I think it was on Thursday or Wednesday or something. No, I should not be doing that here. Hold on. We talked a little bit about conspiracy and my fears regarding conspiracy itself. And this was the day when, again, they were grappling over Quimby. It's been a while since I've been out there. Okay, we'll watch Quimby. I actually wanted to get on the case itself, but let me quickly say this, okay? On, I believe it was Wednesday, when we discussed some of the jury instructions, or at least the back and forth during that hearing between the prosecution and the defense. And I liked when the prosecution brought out Mr. Floyd, because I love trials. By love trials, I don't mean watching them. I love going to trial, and I love case law. So I appreciated when they came out with case law, and then how they were discussing the Pinkerton doctrine. Okay, one of the words you'll hear me, it's not really a word, it's a phrase, but one of the phrases you'll hear me say over and over again, or principal tenet, is a locus classicus. Okay, that means that a case is the primal authority on a specific subject. In this case, let me give you no, I'm giving you guys too many examples. Never mind. Let me just complete my thought. So in this context, right, we're dealing with a conspiracy to commit RICO. So at least as far as conspiracy is concerned, the Pinkerton doctrine is going to come into play. I really wanted to bring up the case itself, but that's not what we're gonna bring up, because I searched for it on YouTube and not in Google. So, okay, I've never watched this video before. Hopefully it's accurate, but it's Quimby. Quimby is pretty reliable. Some of us use that in law school. They have flashcards and they have all sorts of materials that are good. So I'm pretty sure. And again, over here, this is fantastic. I have my glasses on tonight, but I also have to remember to put them away. So this is a United States
responsible for
okay,
not
hold on.
only the
So this is a decision, but this will I hope they don't strike my video down. In any event, when it comes to stare decisis, something in reality occurs. People go to court. When they go to court, they resolve the dispute, or at least they try to, and that's where case law is born. So depending on the hierarchy of the court that's making this decision, it can become binding authority on the entire country if it's from the Supreme Court. If it's from a specific district court, then it's for that jurisdiction. If it's state specific, then depending on the hierarchy of the court that handed out the decision, it can be binding or it can be persuasive. In this context, this is a binding decision. Okay?
you and another person agreed to commit a crime in the future. That is, you entered into a conspiracy. Afterwards, you did nothing to further the conspiracy and had no knowledge of what your co-conspirator was planning. Your co-conspirator, however, decided to take action by himself. He committed not only the crime that was the direct object of the conspiracy, but also other related crimes in furtherance of the same object. Are you criminally responsible for not only the conspiracy offense, but also the offenses that he committed in furtherance of it? The United States Supreme Court addressed that issue in Pinkerton versus United States. Walter Pinkerton and his brother Daniel lived on a farm in rural Alabama.
Okay, never mind. So I won't have to bring up the case itself, because we're going to go over the facts of the case, and they are already discussing the facts of the case in here. So why would we do it twice?
They conspired to buy whiskey in a wet county in the state and then sell it illegally in their dry county. They also conspired to avoid paying liquor taxes to the federal government related to their illegal sales.
Obviously, it's a problem because they were trying to, they just weren't paying taxes. That's part of it. I'm kind of making light of it, but let's get in here.
Walter proceeded to carry out their plan, but Daniel wasn't able to participate in the criminal enterprise because he went to prison for unrelated crimes. Federal revenue agents eventually discovered what Walter was doing. They also discovered that Daniel had conspired with Walter, but hadn't been a participant in Walter's criminal activities. A federal grand jury charged both brothers with conspiracy to violate the tax laws, as well as with several substantive offenses. That is, specific completed violations based on illegal sales of whiskey without the payment of federal liquor taxes. The brothers went to trial. The government's evidence proved the brothers entered into a conspiracy, but also showed that Walter alone committed the substantive offenses without any assistance from Daniel. The court instructed the jury that they could convict Daniel of the substantive offenses committed by Walter if Walter did them in furtherance of the conspiracy. Daniel objected that he shouldn't be legally accountable for anything other than the conspiracy charge. The district court overruled the objection, and the jury convicted both brothers not only of conspiracy, but also of several substantive offenses. The court sentenced both brothers to 30 months in federal prison on the substantive counts and concurrent 24-month sentences on the conspiracy counts. On appeal, the United States Court of Appeals for the Fifth Circuit affirmed Daniel's convictions and sentences. Daniel successfully petitioned the United States Supreme Court
This is what I mean by hierarchy. It depends on the. I'm just going to leave it there. I'm pretty sure you understand what hierarchy is.
to review his case.
Okay, so they did not. I need to stop saying they, them, he, she. In any event, so they did not, or this Quimby did not, in fact, address the Supreme Court in its entirety. So let me just bring it up here. Pinkerton v. U.S. Hold on. Okay, so this is the, let me share my page. This is the, I think you can see, can you see my, I think you can. Yeah, there we go. All right, so this is brief. This is not real. It is authority, but it is authority, but for real research, this is not where I'd go. But in any event, it's good enough for today's purpose, okay? I could break all this stuff down, the citations, and we're not going to do that. But basically, what the court held in this case is that any crime in furtherance of a conspiracy that is reasonably foreseeable may lead to criminal liability for any member of the conspiracy, and that's why I've been talking about the, not so much. I need to stop saying the dangers. My fear about possible convictions, my fear about convictions in this case is because, as we saw from Quimby, we don't necessarily, all participants do not necessarily have to participate in order for them to be convicted. Okay, let's just keep, no, why did I do that? Hold on. We're just going to go to the very bottom here. We're going to go to the ruling. These are footnotes. We don't want that. Hold on. Hold on. This is not. Just a second. We just need to pull up the actual case. Hold on. Let's pull up the actual case and not Justitia, because that's wasting my time. That is wasting my time. I don't have that kind of time. Who was on here? You had Ryan Quist. You had Marshall. It's actually a really, I mean, it is an old case. I don't even think my mom was born 1946. I know that's just me saying random things. Yeah, my mom definitely was not born then. One moment. I should have pulled this up. Before I got on here. Just a second. Wait. I'm going to play this while I log into... I'm going to have to log into something. Hold on. And the last thing, again, I want to do lyrics. I want to go over the lyrics, but I don't want to be up. At least this is the one night when I really, really do not want to be up until... I don't want to be up until 2:30 in the morning because, I mean, it's Sunday, but I have things to do. Let me put it that way. I'm getting distracted. Hold on. So let's go back here. No, that's my page. We don't want to be there. I mean, we'd love to be there, but that's not why we're doing this. Hold on. Blah, 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 blah. Wait. Hold on, I need to go back to law and crime. I do not script. I do not script my videos. I mean, I have a general topic. I usually have a general topic and I have material to go over. But other than that, I do not script. I do not script any of this. I quickly want to go back to the jury instructions. They have so much of Diddy on here. No, I'm on the wrong channel. That's why. Law and Crime Trial, I think that's what it's called. Right. There we go. So let's go back. Today is Saturday, kind of. We want to go back. Is it 2 days, 3 days? Has to be. I'm just talking to myself at this point. Hold on. Anyways, let's watch this mess for a little bit. Let me share. Why is it not sharing? Let me share. I'm just gonna get into some mess here quickly because I cannot see the screen. Hold on. All right, I think this is it. I'm gonna get into some mess while I find the actual case, so you might as well.
With ClickUp, you can easily manage your team's tasks and timelines in one.
Correct.
And at
No, that's not
57.
why. Hold
That's
on.
58. Go ahead. You, David. YSL ruled the world.
It's on the. Oh my goodness, I don't even want to see that.
You indicated that Glock 27.
After.
Is that it? I don't know. I'll leave it here while I log into my
You
account
saw
to
the search
get.
warrant for Jeffrey Williams' home.
Before his.
Yeah, I'll leave it here while I log into my account to get the decision.
For his cellular devices and for gang evidence.
Okay. Okay. So in Mr. Williams' home.
Correct.
All right. In your affidavit is
We
what's
are
used
not doing
to develop
that.
PC or probable cause for the judge to rely on, right?
Correct.
And in your affidavit, I think it's in the 4th page. You reference a post that you saw on the internet about Jeffrey Williams posting YFN, and this is already in evidence. YFN, if ain't like you, like what you do for your mother and kids, I would have been killed you, right?
Correct.
That's referenced in your affidavit.
I don't want to hear those words.
You also.
I'm just gonna skip.
2 pages after that.
Pinkerton.
Whatever
Doc.
page you have it, I have in the beginning it says details for.
I'm gonna have to see the page because these pages are out of, whatever I have is not the same as yours. Okay, no, I see that one. Okay.
All right. Also in your affidavit, you include a text thread between
316
Mr. Wooney Lee and Mr. Williams, correct?
Correct.
And
this is so random, but what is this? The music that they played. I do listen to crappy music. You'll eventually you'll eventually get to see my playlist, and I listen to things I have no business listening to. Okay, but that's it. I thought Wooney Lee's music was actually really good. That I know it's random, but yeah, I
as
had
part
to
of this
put that on
text
the
thread,
record.
you draw the judge's attention to a specific line, correct?
I included that amongst other things in the affidavit, yes.
Well, there's one particular line that you put in a bigger font and you also circled it, or it's circled, correct?
It's circled, yes.
Okay. And you circled it to draw attention to it, correct?
To what I was referring to, yes.
Yes. And the line that you circled to draw attention to was YSL rule the world, kid, 24M on an N head, correct?
Correct.
Okay. And you wanted to highlight that passage said by Mr. Williams in the text.
Okay, I actually found more information. I know I'm always going down rabbit hole. That's not really that's not really what I was looking for, but I found some really good information on conspiracy that I'll share in a little bit, but let me I need to get back on track. Hold on.
That's right, correct?
Correct.
You wanted to highlight that for the judge.
Amongst other posts, yes.
Okay. What was he referring to? Why did you feel it important to highlight 24M on an N's head to the judge?
All right, let's quickly do this. I found a simplified version, okay? Because I don't want to confuse anybody from here. I don't know that there's anybody in here that has I mean, I guess you're here because you have some interest in law. But let's get a simplified version of the Pinkerton doctrine, okay? And doctrine really just means principle, all right? So, okay, do I want to break down the makeup of a case? Should we do that? All right, in any event, usually what you have in a case, you have the facts of a case. That's pretty much what happened. Um, if there are convictions in this case, absent jury nullification, okay? We've gone over some of the charges in here, and I remain steadfast that the RICO, or at least I think it's really conspiracy to commit RICO. I have concerns about that because I do believe that the prosecution has proved that aspect beyond a reasonable doubt, unless I'm missing something. But we'll quickly go over those elements as well. Um, that said, though, so if this case goes to appeal, if there's a conviction and the case goes to appeal, the facts will be the allegations. All right, they'll talk about the defendants, what it is they did, the so-called criminal conduct that they engaged in, and the like. The issue, typically, it is tailored to a specific issue or subject that the parties want the court to address. Okay, so in this case, for example, if let's say SB is convicted, the issue might be something along the lines of them attacking the prosecution's what is this, the manner in which the prosecution has presented its case and the like, and saying that there was insufficient evidence or something along those lines to actually convict SB. Okay, when it says held, that is really the court's decision. What the court or the majority decided. You get the majority and then you get the dissent. The dissent, these are, I wanted to give another example. There's no need to give an example here. Just tell them what it is. So a dissent, usually you have a panel of judges. When you get to appeals court, and even the Supreme, obviously, I'm pretty sure you know the Supreme Court has justices. Not all justices, because everybody or most people interpret the law differently. Okay, if we're quickly going to take a look at the justices on the Supreme Court currently. Looking at their prior or their resume, the prior jobs they've held prior to being appointed, is usually a good starting point, because we tend to align with, I would like to believe, at least as far as in the criminal context, a lot of us align based on what our beliefs are, right? What I mean by that is, if you look at Ketanji Brown, I think it's really Ketanji, or is it Ketanji? I think it's Ketanji. I think I'm saying her name right. But if you look at Ketanji Brown, she has the background of a public defender. Okay, so there's a decision that was handed down. It was sometime last year. Again, I don't want to overcomplicate this. There's a decision that was handed down. No, was it last year? Yeah, it must have been last year, because I was still a public defender last year. In any event, I'm talking to myself. I'm trying to get my timeline right. But there's a decision that was handed down. It was related to, I believe it was criminal procedure. Anyways, either criminal procedure or evidence, but it was definitely within the realm of criminal law. A decision that was handed down, and most of the folks on the, or at least most of the justices on the Supreme Court currently, a lot of them have conservative ideals. And when it comes to criminal defendants, they are more likely to make decisions that somebody that is a public defender would not align with. So in that decision, in that criminal decision handed down from the, I was about to mention one of my prior jurisdictions. I'm not going to do that, because that was actually a really interesting decision that, never mind, I'm not going to over explain. So a dissent, it's basically justices that do not agree with the majority, okay? And then the discussion ratio, decidende, that's how they, the rationale, how they got, arrived at their decision. But in this Pinkerton case, or at least the doctrine, it basically held the court's ruling was that there was enough evidence. Obviously, we got the background on the two brothers. Um, they held that there was enough evidence of conspiracy to submit the issue to the jury for consideration. As a result, the convictions in the lower courts are confirmed. And we understand that both brothers were convicted, even though the other brother was incarcerated at the time that the brother was engaged in criminal conduct. And again, the issue was whether there was sufficient. What just happened to my? I don't know. The screen moved. Whether there was sufficient evidence to implicate the Daniel brother in the conspiracy. Okay, that's what we are dealing with. So Brooklyn said, "Hey Brooklyn, what's your estimate of the value of the watches?" Brooklyn, I'm one of those really cheap people. I don't. Every once in a while, I might splurge money on something, but I don't wear jewelry outside of earrings. But that said, I looked it up. I think it was called an RM something something. Let me see. What's the watch? Um, I cannot find. I can no longer find. I can no longer find. What is this? I can no longer find the watch that I looked up on my device, but I believe it was within the region of $300,000. That's a lot of money. That is a lot of money, but that is what it is valued at. At least that specific brand. Think, didn't he say RM55 or something? Is my memory failing me? Let's see. RM55. I think this is it. Yeah, the Richard Millie RM055. What's the price? Sheesh. Oh, okay. I see a used watch here. If you are interested, Brooklyn, a used watch is going for a little over $298,000. That's a lot of money. That's a lot of money. All right, let's go to the actual website. Actually, let me just pull it up here. I think we're done with this, so we don't need this page no more. We don't need this page no more. RM55. All right, so that's, I don't know. I don't think that's what I looked up. Right, this is it over here. As far as for 2.5 million, I don't even know what kind of person would wear this or why they think they need to wear. But then again, that's not something I'd spend money on. This is literally my first time. This is my first time on this website, okay? Apart from this case, I had no reason to look up this watch. All right, so let's see. Okay, apparently they tie this watch in with golf somehow, so I guess it's Lux. I do like the architecture though. I like the design. So that's all right. So some wealthy folks out here, or at least that's just the model. Where's the price? I don't know. Let's see. What are they saying about the brand? All right, come on. They have history. We're not going into all of that. But from what I've seen, it's about $300,000. And they deliver this in 2 to 3 days. I would think, though, oh, you only have 7 days to return it. I would think that considering how expensive this watch is, I'd want it within like a day. Like they need to fly this to you. I don't see why you have to wait 2 to 3 days for it to be delivered if you're paying this much money. So this is apparently the value of this watch. This is the value of the watch. And then let's see, Brooklyn's other comment. Paige Whitaker reminds me a lot about Amy Coney Barrett. I would think so. I can I can see that. I can see that. Let's that. What do you mean? Check this out. 2.5 million. Oh, which link? Should I go back? All right, let's go back. Here, is that where you want me to go? Sheesh. Let's see. I don't even know what's Black. Oh, I should have gone. Let's see. Have a Black Friday deal. Okay, that's gone. All right. They give you 5% off. I guess it's a lot of money considering. Okay, now this does not. I don't know. This looks like a bicycle or something. I don't know about all of this. I don't know about this. Uh, according to me, it's overpriced, but what do I know? Okay, New York, Miami, Beverly Hills, where the money resides. I don't know. What did you want me to click on? I don't know what Brooklyn is saying. Brooklyn, please type out complete sentences. Okay. All right. So I quickly want to touch on I quickly want to touch on let's quickly touch on what is this? Conspiracy as a whole, okay? Hold on. Hold on. I want to touch on conspiracy as a whole. Let's just get back up here. I was trying to figure out the date. 4 days ago. Mm, is this the day? Is this the day? Because oh my goodness. These ads are killing me. I clicked on Quimby and now they're going to be bothering me. All right, let's see. Is this was this cross? Hold on. I don't know, was this cross examination? I want to go back to jury instructions. I just cannot remember the date off the top of my head. I could get my notes, but I'm tired of getting up. So, no, 10 days ago, that would not be it. 3 days ago? How long was that? No, that would not. Would that be it? I don't know. Let's see. All right, let's go past. I was very impressed with Floyd. I'm going to keep saying that. I was thoroughly impressed by him. And I mean, obviously, I'm biased because I think Short is the best in this entire trial, but is she handing down her decision? Maybe I went too far. But I wanted to go over conspiracy portion. No, actually, I think it was who's this? I think it was Edkins. Let's see. And then I think it's also really important to take a look at. Oh, I'm not sharing the screen. Hold on. I think it's important to. Which screen is it? Is it this screen? There we go. I think it's important to take a quick glance at those pleas because um, the prosecution admitted into evidence some of the co-defendants' guilty pleas, right? And then also this past week, or was it last week? They also admitted SB and I believe Gotti's um pleas, but I'll have to. I know SB for a fact. I cannot remember. I think it was for both. Anyways, I'm just out here debating with myself. So I just quickly want to listen at because again, this is a repetition. Even though the standard for a directed verdict differs from what is this? Differs from beyond a reasonable doubt. A lot of the arguments are going to be the same, but they're going to add on to it. So let's get a recap. Was it the RICO? I think. Anyways, let's get a recap on the RICO before we get into those elements. And then we will see if we're going to stop, depending on time, if we're going to stop here or if we're going to move on. And then I have more. Honestly, I'm tired of talking about Kayla and SB. But I do have a bit more of that on spousal testimony as well as, no, what am I saying? Testimonial privilege and spousal privilege. There's a distinction there. And I think the reason, I know I should just let this thing play. But part of the reason why I have this on my mind is based off of a comment that Dennis left on my channel. I want to say yesterday, but at this point it's really Friday, right?
Your Honor, to aid in argument for the court, I'm going to be
Let
addressing.
me see, what's Brooklyn saying? Brooklyn is saying that Shard is a good cross-exam lawyer, but Doug is amazing at opening and closing arguments. So for Doug, I guess, let me give him a fair chance. I'm going to take another look. I'm going to take a look at his opening statement. And Shard, without a doubt, is a great cross-examiner. And to me, that is the benchmark for a great attorney. Because cross-examination, how much an attorney can elicit during cross-examination really shapes the case. Because the response from the witness, that is evidence that a jury or fact finder can take into consideration. As far as closing arguments, opening statements, that's not evidence. So that's why I think, in my opinion, I mean, if I think it, it's obviously my opinion, but that's why I think Shard is a brilliant attorney, and that's why I think that he rises above the rest. Because it's one thing to have a theory or a theme, painting a roadmap for the fact finder during opening, but if you cannot elicit that information during cross-examination, then you've not really done anything. You've not done any justice to your client's cause. But let's play this quickly. I don't think he spoke for that long, but I really want to touch on conspiracy as a whole. And then I guess we're going to move with Brooklyn's, we're going to move in Brooklyn's direction and just find a little bit of Doug's opening, and then we'll call it. And I wanted to end the night on some BS though, but I wanted to end the, I know I like messy, and I like chaos, but I guess I'm not doing that tonight.
And Demur.
No, we are going to be very chaotic tonight. So I think, yeah, let me think about it.
Count one RICO. And if the court has further questions on the lesser included of the 131, Mr. Abadi's going to address that. Mr. Floyd, if the court regarding the Rodriguez case, which was a case he handled on the Demur on the street gang, if the court has more questions on that, and then Ms. Hilton would handle the remaining counts of the
Then
count
we're
one.
also going
I
to
just want to give
touch
the court that overview.
a little bit.
As the court's aware,
we're just going to touch a little bit on what is this? Racketeering itself, okay? Because I feel like I'm focusing, I mean, I should focus on the conspiracy because that's really the gist of that first count. But we'll touch base a little bit on the RICO itself.
where, Your Honor, the
These
charge
people in
as
these
alleged
comments
of
are so
conspiracy,
mean.
the state believes that there has been ample evidence that a rational juror could find that they conspired to commit at least a pattern of racketeering activity. And obviously, defense counsel has focused on the money or proceeds.
Random, but conspiracy is actually, it's an easier tool than an attempt, okay? I'll leave it there. I don't want to, yeah, let's leave it there for now. I'm going to put a pin in it.
The state believes that for purposes of directed verdict, the easier one to start with is, which is count 12 of the indictment, and the 3 criminal.
And then here, this person is saying that both are felons, and if found, let me stay on track, okay?
Objectives as the court outlined in our proposed page 12 of the indictment, Your Honor.
All right.
That focus.
So, Brooklyn, what are you basing it off of? If you're saying that Doug did not do the opening statement, but you're also saying that he is amazing at opening and closing, what are you basing this off? Is there another case that we can look up, or Wagwan?
Focus on murder, aggravated assault, acts of violence, as well as intimidation of law enforcement and witnesses, which is, I give them numbers in terms of the order of the bullet points. I believe that that's the easier argument or more efficient.
All right, let's go
to commit at least a pattern of racketeering activity. And obviously, defense counsel has focused on the money or proceeds. The state believes that for purposes of directed verdict, the easier one to start with is, which is count 12 of the indictment, and the 3 criminal objectives as the court outlined in our proposed
so meaning here.
Page 12 of the indictment, Your Honor.
All right.
That focus on murder, aggravated assault, acts of violence, as well as intimidation of law enforcement and witnesses, which is, I give them numbers in terms of the order of the bullet points. I believe that that's the easier argument or more efficient.
Somebody said now we're going to be bored together.
Right. I mean, if the state has alleged 2 different ways of the defendants having violated RICO through a RICO conspiracy, and y'all only have to.
And Bougier said 12 people will never agree. This is it's a convoluted case, and that's why I keep saying that if this jury, in order to come to a fair verdict, if they are in fact going to take their duty seriously, I anticipate them deliberating for a minimum of a month, and a month is not even enough to go over all the charges and the evidence that was presented in this case. But if this jury deliberates anything under, I really want to say even 10 days is not sufficient. If they deliberate under 10 days, then that, in my eyes, would be jury nullification, meaning that they're returning verdicts of not guilty on all counts. In order for them to come to a unanimous agreement, it is going to take a lot of deliberation, and it's going to take a lot of combing through the evidence, and some members convincing others of their positions and why. What's Brooklyn saying? Brooklyn says, I don't think jury will find guilty on RICO, but firearms by a convicted felon is 20. The firearms is, to me, that's a given. But then again, that's if the jury does not take if the jury decides to go the jury nullification route, then without a doubt they might get acquitted on all charges. But as far as a felon in possession, I foresee convictions there. For the RICO, I think for the RICO, from my perspective, I also foresee a conviction there. The only thing that I'm kind of on the fence about, let me not say the only thing, as far as the Merck charges, at least as it relates to, what's his name? As it relates to drinks, I think SB did that. But I think there's a lot of reasonable doubt surrounding the circumstances under which it occurred. And that's why, again, I'll keep praising Shard, because he did brilliant with that cross-examination, especially when it came to, as it related to the footage at the traffic light. And the reason why cross-examination is important is because you get to plant seeds of doubt into the jurors' minds. You get to muddy the water. Whereas if you're not somebody like Doug, he's not doing that. So what is this? Mark wasn't effective Thursday. and Doug got 3 directed counts thrown out. That was a given, Brooklyn. That, without a doubt, even without the reason why, the main reason why those 3 counts were thrown out was because those are really Jeffrey's counts. We all know, at least if you've practiced, you'd know that flight is not a sign of guilt. And a few weeks ago, even before we got to, a few weeks ago, before we even got to, before we got to the motion for directed verdict, if you were on my channel, you'd know that I talked about a Supreme Court decision that basically held that, I'll just give you the facts because I don't want to overcomplicate this. But this person was charged with, I believe it was either firearms for sure. I cannot remember if drugs were involved in that case as well. But what happened was that this individual was stopped and arrested as they were leaving their apartment, their own apartment. Okay. There was nobody else in this residence, and there was no question that the apartment, in fact, was this defendant. Okay. But even in that case, because initially this defendant was convicted, but it was the conviction was overturned on appeal. And the court's reasoning was that without him actually being found in actual possession, I mean, there is constructive possession, but even without him being found in actual possession of these illicit substances, that was not sufficient to secure a guilty conviction. So again, that was foreseen. I knew that was going to happen because, I mean, Judge Whitaker does, she's here and there, but she does seem to be the type of judge that, in fact, follows precedent. So that was a given that that was going to happen. And again, had Jeffrey remained on the case, those charges would not have gone away. The difference, again, if beyond a reasonable doubt is a different standard. Beyond a reasonable doubt, it's basically the jury saying, okay, I am doubting, or I have, that's not a right way. I need to find my notepad. Let me simplify this. In order for a jury to acquit, no, that's not a good way, because that's burden shifting. In order for a jury to convict on a count, they should not hesitate. Okay. If you're hesitating, if they're hesitant, that is reasonable doubt. Whereas for a directed verdict, basically the standard is this person should not have been charged to begin with. Okay. Those are the two different standards. Let's see. Brooklyn says, but not burden of proof. I don't know what that means. And then for Rico, I don't know what that means.
Prove one, you don't prove both.
Correct,
So
Your Honor.
you're saying there's at least evidence as to the overall purposes, part B of RICO.
Correct, Your Honor.
So you have to focus on Brooklyn. Hopefully you just heard what Whitaker said here. Okay? Because it's one thing, it's one thing to watch a trial hoping for a certain outcome. I am really, even though I do joke around on this channel, I have no dog in this fight. I mean, there came a point where this trial had worn me out. I was frustrated. I was over it. And that's because Love and Steel, insufferable. I could not stand both of them. They exhausted me, and I was just over it. But the case has become more, I could digest it better once those two exited the trial. So yeah.
And
But hold
a
on.
couple
Did I
things
go
is
back?
in terms of
Through a RICO conspiracy, and y'all only have to prove one, you don't have to prove both.
Hold on. Did I go back to the right spot?
the
Oh my goodness.
It's my favorite time of year.
All right, come on. No, did I go? No. No, I do not want to go
acts
too
of
far
violence,
back.
as well as intimidation of law enforcement and witnesses, which is, I give them numbers in terms of the order of the bullet points. I
But the
believe
reason why I'm going back is for you to pay very close attention to what Whitaker is saying, okay? And okay, let me leave it there. I'm always over explaining.
that's the easier argument or more efficient because there's
Right. I mean, if the state has alleged two different ways of the defendants having violated RICO through a RICO conspiracy, and y'all only have to prove one. You don't have to prove both.
correct,
So
Your Honor.
you're saying there's at least evidence as to the.
And Brooklyn, I'm gonna ask you this: Why do you think? Why do you think the jury cannot? No, that's not what you said. Let me just go back. Hold on. Let me put my. I'm gonna put my bifocals on. Let's see. I think I read somewhere here. Hold on. I don't see it. I believe if I understand you correctly, you're saying that you don't think the state has proved its case beyond a reasonable doubt as it relates to the RICO. Why do you say that?
Overall purposes, Part B of RICO.
Correct, Your Honor. And a couple things is in terms of that objective of racketeering activity, specifically the murder and the aggravated assaults. You have from the defendant's own words their and tattoos, their allegiance to YSL. I don't want to cite a litany of cases, but there's a number of factors that courts use to establish an enterprise. For example, United States v. Harris, 695 F 3rd 1125 1136 is a 10th Circuit 2012 case, is display of colors, jewelry, clothing, all of those are just three to start. You also have tattoos, which are permanent. And so Mr. Kendricks has slat on his left forearm and a large snake that was introduced, I believe yesterday or day before, on his stomach that goes up to his neck. You have defendant Stillwell, who has multiple admitted exhibits and posts that reference slime or reference his, for example, exhibit 430 VV is defendant Kendrick over at Act 133 with a red bandana and a YSL pendant. State's exhibit 511 VV as admitted is over at Act 138 is defendant Kendrick with a hat with a rat crossed out on it. State's exhibit 38 November is over at Act 134 where you have Kendrick pointing at the cameraman, two individuals.
Okay, I was gonna say something about RICO, but let's let him finish. I just want Whitaker to make a point, and then we'll take it from there.
With Make America Slime again, and I could go on, but the point being, you have both 2015 exhibits where Detective Gaither and Detective Dennis, you had Twitters of Mr. Sledge, you had Twitters of Mr. Zachary, Twitters of defendant Stillwell, where multiple, and I'll give a few examples that actively and openly possess my slimes, YSL, this is my brew. And that allegiance coupled with the evidence at trial of the murder of Donovan Thomas to begin with, which is captures over at Acts 16 through 20, which the evidence of that murder from the interview statement of Kenneth Copeland on June 10th, 2015, and Quindarius Zachary on August 15th, 2015. Quindarius Zachary's interview, which was played for the jury and is in evidence, states that defendant Kendrick and Stillwell confessed to him that very night. And defendant Williams Condo, who rented the Hertz rental vehicle that the Infinity rep, Mr. Thomas Burnett, stated from watching the surveillance video, which I believe is 296 Yankee, that Detective Teague with APD introduced, that was an Infinity Q50.
Let's see, what's Brooklyn saying? Brooklyn says because for RICO you need to say he got the drugs from, let's say, no, 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 not El Chapo, no. That's not how it works. Let's get to that's crazy. Let's get to there's a point that what's her name? Whitaker made as it relates to Rico, and I just wanted her to say it again. Let's get there, and then we're quickly going to touch on Rico. We're gonna. All right, never mind. Let's play that.
All of those things.
And you have to realize that Brooklyn, you have to realize that for the predicate offenses of a RICO, it goes beyond drugs. It is not restricted to drugs, okay?
Combine that statement of Copeland and Zachary for the why it is a criminal enterprise murder. There's no personal.
And you have to, again, if one thing we're keeping in mind, it's beyond drugs, okay? The prosecution has a number of predicate offenses, okay? Some of those obviously statute of limitations have lapsed, so they cannot be a factor as far as a conviction is concerned. But there are predicate offenses that are going to survive a statute of limitations challenge, okay? Here's the thing. Let's talk about Lil Woody a little bit. I think, and this is going to require a larger discussion. But for tonight, I really want to restrict this topic to the RICO. I mean, we started off talking about civil and criminal forfeiture or asset forfeiture. Okay. But that said, if we have to, and I mean, we're capping this off with RICO itself as well as conspiracy. Okay. But if we have to consider the task that or the responsibility that the jury is tasked with here, part of their responsibility is assessing credibility. Okay. Credibility is going to be a big issue in this case. And again, the defense did a fantastic job as far, and by defense, I really mean Shard. Okay. They did a fantastic job as far as attacking witnesses' credibility in this case. What I mean by that is if you, as an attorney at trial, you do not have a legitimate way of attacking the evidence that the opposing party has presented, then your next line of defense is credibility. If you can what is this, plant the seed of doubt in the jury's mind as far as a specific witness is concerned, then that is going to be good for you, because then the jury is not only going to question that witness, but they're also going to disregard whatever it is that they said. The thing is with Copeland, though, Copeland, that immunity should not have gone to him. I don't know how or why the prosecution thought that that was the best person in this case to give immunity to. They should have given that to Obama. If not Obama, give it to one of the younger kids, because they'll talk. All right. That's it though. Woody obviously has drawn a lot of attention to this case, and that's how we ended up with Kayla Bumpus. But for Woody firing Kayla, it really would not have, at least this Mary. I'm still gonna say alleged, just because it's inconceivable I don't know, something happened to my internet. But I was literally talking. I was talking and I had not realized that my StreamYard was disconnected. But I went on a tangent. I was talking about credibility. I don't know how much of that you've heard, but let's quickly move on. Let's wrap this entire thing. Again, I don't know when this stream cut, but what I was saying is that um focusing for the defense to focus on a specific predicate act or sole. Let me say that for the defense to focus on a sole predicate um, offense as it relates to the RICO is a mistake. And the reason why it's a mistake is because the prosecution has an avenue. They literally have a litany of predicate offenses that they can choose from and persuade the what is this, the jurors to um, find these defendants guilty. But let's just quickly recap because I don't know, my Wi-Fi just that was so weird. I have no idea why that happened. But I was literally talking about witness credibility, and I was talking about what's his name, Copeland. And I'm not even going to go into that because it's kind of unrelated. But let's quickly take a look at what is this? Let's quickly just touch a little bit. We're gonna touch a little bit on predicate offenses and RICO, and then we're gonna go to the conspiracy. Okay, so just overall, I need to put my hold on. Overall, right? Again, I've reiterated how a RICO or the act itself is a powerful tool that the what is this, the prosecution or the state uses, right? And this, typically the legislations or the statutes, they target enterprises and they basically seek to punish everyone who is what is this, involved in any type of racketeering activities within an organization. Okay, so again, there's specific activities that are, or enumerated activities. I don't think it's an exhaustive list though. It's usually, typically in criminal cases, it's never an exhaustive list. But there are a number of there are a number of what is this? There are a number of predicate offenses that a prosecution would have to prove as far as a RICO charge is concerned. Okay, and then for you okay? Bless you. And then for any member of this organization to be charged under. You need your water bottle? All right, hold on. Hold on, folks. I am parenting. So let me I'm gonna put what's his name on? I forgot his name. So I'm gonna put this. All right, you need to focus, 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 focus. Hold on, I'm gonna pause here because I have commentary. I just need to get some water. Hold on, because if I could rewind in like 10-second increments, that would be great. But I cannot do that from this device. Come back. this thing still connected? Oh, hold on. I'm not even sharing my screen. What a mess. Let me share. Let me share my screen. Is this it? I think this is it.
One call around 2:00 a.m. Fast forward, you have two shootings at 1903 Drew Drive and 1428 Adele. You had testimony from Ms. Bell, whose home was shot, crime scene technicians and responding officers. And you had in the interview and testimony of Zachary and Sledge, that act in concert, which was only 3 months after the murder of Donovan Thomas, shooting at, intending to strike rival opposition members, the ABG, Inglewood family, YFN, that group. So from January 10th, 2015 to March 14th, 2022 of the
Did I
murder
go
of
too
Shamel Drinks,
far?
the targeted acts of violence in concert by YSL members is towards the same opposition group. And that's significant for multiple reasons, because as the court knows in RICO, evidence can have multiple relevant purposes to both prove the criminal enterprise and also prove the pattern of racketeering. And I think what is important in this case is, although the state did not allege subsection alpha or bravo of the RICO statute, actual commission of racketeering activity gives clarity that this conspiracy was not some fanciful idea. It was actually the best evidence of a conspiracy in a group is a decade's worth of similar victims, methods of operating, and public and active allegiance to this YSL enterprise afterwards that this case and the evidence through testimony and exhibits has established. So the courts or the state, as a number of other factors, and I will not rattle off all of these cases that are other factors the court
Okay,
looks to
we're
an
getting
enterprise,
somewhere.
gang and hand signs. There's been
Brooklyn, I see your other message. I will address that shortly, but I'm trying to get to Paige.
evidence admitted in testimony from APD gang detectives of the quintessential YSL hand sign, the wiping of the nose, greeting phrases the court has heard and seen in text messages and wiretaps, slat and slime.
Why don't you move on beyond
Yes, Your
enterprise to some of the other necessary elements?
Yes, Your Honor. So does the court have a specific necessary element that the court would like to hear?
Well, what were you going to talk about next?
Fair enough, Your Honor. So to give structure, moving on from the enterprise, when in terms of agreement or the defendants agreeing to be a part of this, the state's argument, and again, the evidence can have multiple relevant purposes, the tattoos and the public, both association with YSL members and active promotion through either of that criminal street gang through their own words or social media of showing allegiance to that, posting with YSL pennants, using the common gang identifiers and hand signs and with other YSL members throughout from 2015 to as recently as 2022 shows, and the commission of the racketeering activity shows that they were a part of it. As in, you do not need, of course, a written contract. You do not need, of course, some videotaped round table of discussion. Their actions speak louder than words. And so if you need to, there's ample evidence a rational juror could find that because of the commission of murder, aggravated assault, and continued association, that they have actively agreed to be a part of this enterprise through their very own actions. You also have October 1st, 2015, where Martinez Arnold gets jumped at Magic City.
Embrace the journey, where each moment turns into
by Kelvin Watts, Shell Kell, who of course has been talked about this week in relation to March of 2022, which shows a commonality. And then he calls Mr. Kendrick, who rides with him, where they get stopped with the multiple firearms in the Trestle Tree area, which there's been testimony from Detective Griffin, who was the lead detective on the Tierra Jones homicide. There's been detective from multiple APD gang detectives about where Summerhill or ABG in that area is where their territory, so to speak. So that action, the January 10th, 2015 murder of Donovan Thomas, however many months later you get to October 1st alone, shows a commitment and an agreement by your very actions, willing to either assist or actively participate in racketeering activity. Furthermore, Your Honor, of course, I think the easiest of this, one overt act committed, and of course, one committed within 5 years of the indictment. The state has, I will use because it's, I believe, one of the most readily assailant overt acts is the murder of Shamel Drinks, which the state believes through the testimony of Viverito, the social media introduced, is a rational juror of fact would find that to be street gang related, enterprise related. Again, evidence of anything other than association with a rival gang that is in evidence of why Shamel Drinks would be murdered for going to pump up his car with gas. And so that act is certainly, it is only a few months before the indictment itself. That alone, the state believes there's been ample evidence that defendant Stillwell has committed that act along with other YSL members. And that alone, a rational juror could find happened and was for, going back to page 12 of the indictment, one of the overlying purposes that the state has alleged, which is important, of preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity.
I was going to say something. I'll let him finish.
Including murder. When YSL members were murdered on March 11th, retaliation was needed for the enterprise's reputation and to exact vengeance. And so that overt act alone satisfies. Of course, there is ample overt acts alleged of promoting either the gang itself or violence. I didn't want to run off a litany of admitted exhibits with.
Okay, how about
Yes, Your Honor.
are you going to talk about what the pattern of interrelated racketeering activity within 4 years of?
So, Your Honor, yes.
Yes.
I will take the testimony that has came out related to YFN Lucci or Mr. Bennett. And that is a perfect example of, you have, when Mr. Sumlin testified and the call was presented of Christian Eppinger, who was in the jail, calling him saying, I'm on PC with that boy Lucci. How much can I get for that? Then you have the text messages that were the color-coded charts that Viverito walked through with Khalif Adams, Demikion Garlington, and Jaden Myrick. Then you have the video that from the jail where Jaden Myrick, after that messages about stabbing YFN Lucci, through the testimony of Viverito of what they were discussing, actively tried to stab.
I'm just waiting for what is this? I should have taken the time. I should have taken the timestamp down.
YFN Lucci. Then you have the post of defendant Kendrick predating that, but 2019, I believe, standing on top of YFN Lucci's.
All right, but I mean, a post isn't an act of racketeering. So talk about.
Yes, Your Honor. So you have multiple YSL gang members, all of which, I use that example because I believe it's so salient, of multiple actors, multiple ages, multiple years in time. It's the same individual that they're trying to exact violence on, who happens to be the same individual who was very close with Donovan Thomas from 2015. All of those, that pattern, the victim and the method of operation, using other YSL gang members.
All right, so which acts of racketeering activity are interrelated that have to do with that?
Yes, Your Honor. So specifically, you have.
I mean, this is kind of unrelated. The difference between, what is this? Making an argument before a trial court judge and, let's say, for example, appeals, is a trial court. I mean, you're really making the record. So the attorneys get to do most of the talking. But what with, who's this? What's her name? Whitaker, asking all these rapid or firing all these rapid questions. Typically, that is what an individual or an attorney would be experiencing before an appellate court. But what I had observed during the the motion for directed verdict is that Whitaker, I mean, she has been following. Obviously, she's been presiding over this case for 4 months now. She was already prepared to make a ruling, but in order for her to support her ruling, there are certain questions that she needed answered in order for obviously to reach at least the decision that she was going to reach. Because you'll find that when Hilton gets on the stand, the focus when Hilton got on the stand was really where the firearms that were seized from Jeffrey's home were recovered, and that obviously formed the basis for the dismissal of the 3 counts. And I mean, even when Short was testifying, I have notes somewhere. I have a legal pad in one of these purses that I carry. But even when Short was testifying, I forget to which subject he was on. There's a specific count or counts he was addressing, and the judge pretty much looked at him and said, "I'm not convinced. You're not convincing me."
Let me grab my indictment so I can see
Sure.
the accurate numbers. Thank you, Mr. Porter.
And I wish I had not fast forwarded or moved the mouse, because now we have to listen to all of this just to get to Whitaker.
Put on your Valentino and take off.
So many ads.
Blend in, but stay.
I wonder how much money.
So in terms of overt act numbers,
what is this? Long crime. Come on.
you have Act 171 as the Eppinger and Sumlin conspiracy to commit murder, which was the jail call, which has been introduced. You have
And the one thing that we have to, okay, let me stop. No, I'm gonna make this point now. The one thing that we have to consider is that the Mercs, because we have 3 counts, and the conspiracy, or at least the predicate offense that forms a part of the conspiracy, completely different. They're not. I'm not saying the facts are different, but they're different considerations as far as a conviction or an acquittal is concerned. And I'll explain in a moment what I mean by that. I should not have moved that mouse.
overt acts 165 through 167 is Bobby Hunt, Khalif Adams, Demekion Garlington, Scarface, and Jaden Myrick, which is all related to that February 9th, 2022 attempted murder of Mr. Rayshawn Bennett. And you also have, this is not an overt act, but is quite relevant for this purpose.
You see, and that attempted murk, that is, at least that portion is different from the 3 lone standing counts in here. And that's why I keep saying, I know Brooklyn says not to worry about this conspiracy. But I don't know. I just think there's a lot there.
States Exhibit 227 VVB2 is the text message from defendant Stillwell's phone where he says on February 9th at.
And Brooklyn, I'll get to your second or the other message that I don't have on the screen. I'm just trying to get through to Whitaker, and then we're going to cover what is this, RICO? Because I'd actually started, and then the whole thing, I went off on a tangent, and then I got disconnected. But we're going to take a closer look at conspiracy.
7:31 p.m., which is I believe within 30 minutes of that stabbing, they just wet Lucci's BITCHASS up, which again shows in us, a them, a concert, an agreement, a pattern, a method of utilizing contacts through jail, prison, or on the streets to concoct a plan and enact violence on a rival gang, specifically a rival gang leader, who of course on January 22nd, 2015 and January 26th, 2015, mother's house was shot at 1007 Hill Street. You also have the overt act that is in evidence related to the post from defendant Williams of, if I didn't like what you did for your kids and your mother, I would have been killed you, which was about Mr. Rashawn Bennett, Wyeth, and Lucci. And so all of those things combined, without, you have words in the text messages through somewhat coded language. You have jail calls where Christian Eppinger does mention his name, but you have where they all know what they're talking about, what the goal is. They don't need to go into the agreement and the enterprise's objectives morph into one and the same in terms of without, they don't even, they all have the same common goal of enacting violence on a rival opposition. Is the conspiracy that could be a possibility when I actively join this enterprise is best proven by the attempted murder and the pattern of racketeering proves the conspiracy was alive and well, in this case for upwards of a decade. And all of those, of course, I use because they're more recent. They're well within the 5 years. Your Honor, I also believe that in terms of, an overall pattern.
The only way that's not the only way, hyperbole, hold on. So a manner or way, an avenue for the defendants to be acquitted on the RICO or the conspiracy to commit RICO, the only avenue I see there is if all the predicate offenses are offenses that were committed 5 years prior to the indictment. That's the only avenue that I see. But if there are two predicate offenses that survive that challenge, then this is a conviction. But that's if you can get 12 of these individuals to reach a unanimous verdict, because obviously we still have, was a juror 51 or something along those lines, and I just do not see for the jury to reach a well thought out verdict in this case. It has to be, they have to be, at a minimum, they have to deliberate for a month, and even a month is not sufficient for the number of counts that these defendants are facing, right? And then, I mean, unless they just want to move on with their lives and nullify the whole process.
When you have, of the 28 defendants indicted, there's many connections in terms of Rodelius Ryan was, I believe, 15 when the murder of Jamari Holmes happened. Roughly, the murder happened early that morning around 4 o'clock. Later on that day, he posted a video of, I bet YSL makes the news. He has Instagram messages that are in where he alleges is quite actively stating FUCKYFN, ABG, right? He would have been 11 years old when Donovan Thomas was murdered. When Wooney Lee testifies about, we put that, what on your gravestone, he would have been much younger. He doesn't come up his name in the murder of Donovan Thomas, but the fact that members who either have, actively promoted, tattooed, claim allegiance to this enterprise of different ages, of different times, have the same enemy, the same disagreement through racketeering activity in its truest sense of violence, is the similarity, is certainly for a rational trier of fact to find that there is a clear common interwoven theme, which I use the violence because, again, I believe it's the most salient of this point for purposes of directed verdict.
All right. Can you speak to whether it matters that the indictment itself doesn't contain the language willingly and knowingly, willfully and knowingly?
So, Your Honor, Mr. Floyd was going to address that
No,
much
man,
more
did I
eloquently
miss? Did I miss? Do I really
than
want to
I,
go back?
if that's all right, but with the court.
Thank you. I appreciate it.
Yes, Your Honor.
Man, I missed. How did I mess up Whitaker? Let's see. I'll just play it for you. Okay. Remember, if I cannot find it, I'm just gonna have to come
It's
back.
focused on.
I'm gonna have to come back.
She acknowledged that is the word that they use. Charged at.
It's focused on.
Oh no, I'm gonna drop that because I don't want to have to re-listen to that. But in any event, let's quickly just go over Rico a little bit, okay? Because obviously a lot of people are late, but in any event, as far as what exactly is racketeering, when you hear the word, what exactly is it? Okay, so to simplify it, hopefully not oversimplify it, but to simplify it, racketeering in essence is a type of organized crime. Okay, involves a group of people, cannot be an individual, working together to earn money illegally through a pattern of criminal activity. That's how you get those, or that's why you need the predicate offenses or acts. Okay, but that's just simplifying it. So again, talked about this being or at least we talked about the RICO statute itself being being a tool for prosecutors or state's attorneys' offices, right? And that's why they keep using it. And then, as far as the statute itself is concerned, okay, um, the main focus, it's usually the evidence of continuous or consistent racketeering activity or the existence of an enterprise. Okay, and then again, we're gonna go to I think it was Brooklyn that mentioned something about El Chapo. So we'll get there. Uh, One thing that folks tend to overlook, or at least maybe something that a layperson would not consider, is that an enterprise does not have to be an illegal entity, such as a street gang or a drug cartel. Okay, that is not required. That is not a requirement of RICO. So when what's her name? When Vivarito testified, it's a blur now, but I think that was Wednesday, or maybe it was Tuesday and Wednesday, if I'm not mistaken. But when she testified, she said that, or she testified to YSL not being a typical gang, and there was a lot of I don't want to call it uproar or cheer, at least from folks in the chat. The what I'm referring to is the law and crime chat. They're like, okay, so if it's not a gang, then how are they able to bring these charges? But by its very nature, the prosecution does not even have to prove this to have been a street gang or a drug cartel. That is not a requirement of the statute. Okay, it can be. I mean, we've seen this at least as far as Funny Willis is concerned. She has brought. I hope I'm not confusing her for another DA's office. But she has brought a RICO against individuals that aren't even in a gang. Okay. So it can literally be against a police department or even a family, individual family members. Um, so what is required is basically, at least as far as RICO is concerned, the prosecution has to show that the enterprise exhibits a predictable pattern of racketeering or criminal activity, and then that is basically much that's sufficient for a prosecution to be brought. Okay. And then again, there's a comprehensive list, but I don't think it is all exclusive of predicate offenses or crimes that are included. And these are, arson, drug dealing, murk, things of that nature. Okay. And then let's see. And then as far as that first count is concerned, you have the RICO itself, and then we also have that what is it called? We have the conspiracy itself. And then let's see. Obviously, there has to be a certain number of predicate offenses committed within a specified period of time. Let's see. So let's move on. I think this is a good time to move on to the conspiracy. And for conspiracy, I'm actually going to bring up my book here. I'm not going to be speaking from memory because I had to take another look at this because I just have conspiracy by its very nature. I had concerns about a possible conviction on the conspiracy, and that's me not even considering the RICO, just the conspiracy itself. What I mean by that, you can be charged with conspiracy to commit murder, conspiracy to commit bank robbery, armed robbery, whatever. So a conspiracy itself is kind of, it is under a specific, what is this? It is an incomplete crime. What I mean by that is an individual, a defendant cannot be charged with conspiracy alone. Conspiracy is always in conjunction with another crime, such as conspiracy to commit, again, arson, this, that, and the fourth. Okay. So if we're going to, this is going to be federal law. Okay. So federal law usually lays the foundation, it lays the floor, and then the states can pretty much build onto it. All right. So is my mic? I need to stop touching this mic. So if we go to conspiracy then, okay? The basic definition or the building blocks of conspiracy is an agreement between two or more people to commit a crime and an overt act that is an act committed by any co-conspirator in furtherance of the conspiracy. Okay. And if we go back to the Pinkerton doctrine or the case itself, we obviously know that one of the brothers was not, they entered into an agreement, but one of the brothers was incarcerated at the time that the other brother, I forget the name. I'm just going to say brother number one. Brother number two was incarcerated at the time that brother number one engaged in an overt act. And we're going to talk a little bit about what is this? The very last thing we're going to talk about is what is this? How an individual, or in this case, as far as these three defendants are concerned, disassociation, basically disassociating yourself from the conspiracy and what is sufficient. All right. So we're not going to go over the actus reus because I think I've talked enough about that at least these past 2 days. So maybe I should just, again, actus reus is conduct. Okay. That's literally what it means. It means conduct. And that's usually the first element of any criminal offense. Again, so the agreement itself is the actus reus. So these two individuals, I'm talking about the brothers now. But as far as the YSL, I guess let's stick to YSL because that's what we're talking about. As far as YSL is concerned, the conduct here, or the first element, the actus reus, is the agreement itself, the agreement to conspire. Okay? So an actual agreement is required. Feigned agreement, such as in the case of an undercover police officer, it is not sufficient. So in order to have an agreement, the individuals in here have to, like, I don't know, when Woody says some of the BS, he adds a bit of the BS or whatever as he was being interrogated or as he was really snitching, right? Him to pretend to, in this case though, I don't think he testified to pretending to, I don't think he feigned agreement. In any event, everybody has to be in agreement. It cannot be a case where there's an undercover, an undercover police officer pretending to be in agreement with the other co-conspirators. So that's not sufficient. And then the agreement does not have to be express. They don't literally have to have a written document down saying this is what we're going to do. It can be proved by circumstantial evidence, okay? And that's why I kept stressing that a lot of times, I guess, lay individuals expect to see an express agreement, but that's not always the case. Even folks expect to see direct evidence. That's not how that's just not the reality of criminal cases. A lot of this tends to be tacit or what is it, circumstantial. Okay, so let's see, where are we? Intended to achieve. Basically, the agreement has to show that they intended to achieve the same um, objective, and they agreed to work together towards that end goal. In this case, it seems to be the ops, or at least that's what the state is probably going to argue. And then the agreement does not require a meeting of the minds. That is very important, okay? But merely a shared intent to pursue a mutual goal. So everybody in this YSL ring does not necessarily have, they don't have to agree as to they don't have to agree as to all the elements or all the terms of the agreement. It is enough that they have a shared intent. Okay. And then I did not get a chance to watch all the jury instructions, or at least when the court, with the assistance of both prosecution and defense, were crafting this. I don't know that I'm probably going to do that in my spare time, though, because we're getting ready to get into closing arguments. And I'm hoping at least by, I want to say tomorrow, but it's really today because it's Sunday. I'm hoping that by Sunday, we would have had a better recap of the evidence that has been presented, or at least what the parties' roadmaps were before we get to closing arguments on Monday. And then we're still busy with the actus reus here, or the conduct, right? So the objective of the agreement must be either to commit a crime or to commit a lawful act by unlawful means. Okay, I'm going to go over that again. So the objective, two ways about it. Either the agreement either has to be to commit a crime, or to commit an act that's not a crime, but you're going about it by unlawful means, in an unlawful manner. Okay. And then conspiracy, I think, when was it? Probably on Friday, we spoke a little bit about intent here, the different types of intent. And in that case, I spoke about intent in the context of Merck, though. So those intents, yeah. Let me see. I don't know. Let me not overcomplicate things. So for conspiracy is a specific intent crime. What that means is that the mens rea that is required is both the intent to agree and the intent to achieve the objective of the agreement. And then we're going to go over quickly the overt act requirements. Again, this is federal. This is what the federal law says. Every state, this is the floor. Every state can add to this, but they cannot subtract or detract from the foundation. As far as the overt act requirement is concerned, there's a majority rule that an overt act in furtherance of the conspiracy is also required for a conspiracy liability. So that means that there are certain jurisdictions or states that do not require or that do not require an overt act. And then this view basically, it's a change from the traditional common law rule, where there was no such requirement. Basically, the agreement itself constituted the crime. So from this context, you've seen that there's been an extension of protection, at least as far as criminal defendants are concerned, meaning that under this new development, it is not as easy as it was to convict, or let me put it this way. Prior to this new development or this new way of thinking, criminal defendants charged with conspiracy could be easily convicted. And the reason for that is because all or mostly of what was required was an agreement, because an overt act was not required. Okay. And then the overt act itself for the conspiracy does not have to be criminal or unlawful. It is only required that it be committed by one member of the conspiracy. Does that make sense? So, for example, if there's an agreement to let's see, I'm trying to relate this to YSL. I don't want to come up with an example that is going to contradict the evidence that has been presented. Let me give an example. Yeah, I'm going to give an example that's not even related to this case at all. Let's say that there are folks that associate and they've come up with this agreement, or they're in concert to take somebody out. Okay. And one of these folks go to, I don't know, a Walmart or Target to buy duct tape. The purchase of duct tape is not illegal. That's what it means. And that is an overt act, because they're taking a substantial step in furthering the conspiracy, right? So that's basically what it means. They don't really have to be engaging in criminal conduct as far as the overt act is concerned. Okay. And what is this? Preparation may be sufficient. It may be sufficient, such as again, the purchasing of, what is this? The duct tape, as opposed to purchasing a firearm or a butcher knife or something along those lines. And then, unlike what is this? So conspiracy. Hold on, I'm getting distracted. I'm getting distracted. My eyelashes were distracting me. And then hold on. I'm getting hungry. Just a second. I don't want to confuse anybody. All right. And then we go on. Obviously, every jurisdiction is different. I mean, some of them are the same, but every jurisdiction does not necessarily apply the law in the same way. And because there are jurisdictions that recognize liability for crimes, such as a conspirator aid, or somebody that's basically assisting, it's kind of like an accomplice, okay? And that's under the doctrine of accomplice liability, but that is not, I think that applies to all states. I've not practiced in every state, so let me put a pin in that. So, for example, when a conspirator does not have the sufficient mens rea, against mens rea conduct agreement for liability as an accomplice, then that's where we get to the Pinkerton doctrine that we basically visited at the beginning of this, and that provides that each conspirator is liable for the crimes of all the other co-conspirators when the crimes were both a foreseeable outgrowth of the conspiracy and committed in furtherance of the goal. Okay. So, and that's why I keep reiterating that the charge or the count of conspiracy itself, it presents a, I don't want to call it a pitfall, because that's not really what it is. But the charge itself of conspiracy to commit the racketeering acts or activities, or whatever we want to call it. The reason why they charge this as a conspiracy to commit as opposed just a violation is because with conspiracy, not everybody has to engage in the criminal conduct. As long as the prosecution can basically lay the foundation and show that the crime of the co-conspirators was foreseeable as an outgrowth of this conspiracy, and it was committed in furtherance of the conspiracy itself. And then Okay, we're not even going to go into the Pinkerton doctrine because we have already touched upon that. We have touched upon that, so I don't want to repeat myself because I'm out here. What is this? What time? Hold on. I just need to. Okay, it's 2 p.m., so I'm just trying to rush through this so that I can clean up my kitchen, eat, and go to bed. Let's see. What else do we have here? Okay, we're not okay. Maybe no, I need to touch on this because this is actually very important. Because there are chain relationships and then there are hub and spokes. That's usually how conspiracies are that's how conspiracies are classified. Because it was in one of these discussions, one of these days where one of the folks that joined me on the live, right? One of the folks that were on the panel, they mentioned, I cannot remember which co-defendant it is, but there's a co-defendant that does not actually know Jeffrey Williams. What folks do not understand is that these people do not even have to know each other, right? But they're two, as far as the nature of the agreements are concerned, there is there can either be a single conspiracy or there can be multiple conspiracies. Okay. So this is the distinction between a chain relationship, and that's literally what it means. Just kind of envision a chain. This is where several crimes are committed under one large scheme in which each member knows generally of the other party's participation, and a community of interest exists under one single conspiracy result. And then we have the hub and spoke relationship. So think of this obviously as like a dot in the middle with different spokes, you know, protruding out, kind of like a bicycle wheel or something along those lines. This is where one common member enters into agreements to commit a series of independent crimes with different individuals. Okay. And then multiple conspiracies exist. So for folks that have said that, or that have questioned whether, I just forget which defendant. There was a co-defendant though, and somebody brought up the point that no, but this co-defendant did not even know of the existence of Jeffrey Williams or did not know them personally, something along those lines. For conspiracy, it really, really, really does not matter, and that's why, again, that's why I am pretty much worried about the count of conspiracy. And then we're quickly going to go over some procedural issues that relate to conspiracy here. So one thing to note is that an acquittal, okay, an acquittal of one, we still don't have that here though, because we've had defendants plead guilty, and then you okay, Ma? We've had defendants plead guilty, but we do not per se have an acquittal because charges were just dismissed. But an acquittal of one co-conspirator traditionally results in the acquittal of a single remaining. So if you only have two people, in that conspiracy, for Georgia, I believe it must be three. I think if I remember correctly, the way that the evidence was presented, it must be three. So if that's in fact the case, and in Georgia you need three, at least three co-conspirators for conspiracy, then the acquittal of two would result in basically a dismissal or an acquittal on the single remaining co-conspirator. And that's again, at the federal level, you need at least two guilty parties. But in Georgia, if you need three, if two are acquitted, the third, naturally, I'd argue, would have to be acquitted as well. All right. And then what's important, I'm going to have to put a disclaimer there, because it is not necessary to try more than one conspirator. So even if there's an agreement, for example, let's say in the context of the federal level where you need two individuals, you can have a case where one individual is turning against their conspirator, and under those circumstances, obviously you've only charged one because the other one is cooperating cooperating with what law enforcement and the prosecution or the state. Okay. So a single conspirator could be tried and convicted of conspiracy if his co-conspirators were missing or even if they were deceased. Okay, so that's important to know. And then the common law rule is that no conspiracy exists if only one of the conspirators truly agrees and the other is feigning. And that's where I was trying to come up with that really poor example of law, Woody. So in order to have an agreement, it's not just that at least you need at least two people at the federal level. And I think in Georgia, you need at least three people. Uh, but let's say if maybe you had Woody, you had Lil D, and you had Jeffrey. Those were the three individual. And from the get go, Woody was always just fading because he plans on cooperating. And let's say Lil D was also fading and he really had no interest. And there's only Jeffrey left. That is not sufficient. You need at least, um, three. I think it's three in Georgia, but I stand to be corrected on that point. But at least at the federal level, you do need two. And then what else? What else did I not touch on? Okay, and then there's another approach, unilateral approach to conspiracy. We're not even going to go into that. There's the Wharton rule. We're not going to go into that. Yeah, we're not going to go into that because that's just over complicating things that we do not have to complicate. And then as far as defenses, right, did these folks actually? I don't remember. I don't know. I don't remember the defendants raising a defense in this case, unless I don't know. I don't remember. But in any event, impossibility is not a defense to a conspiracy. What that means is that, let's say, for example, if we go back to that jail call when they tried to take, I need to stop saying they, when it is alleged that YSL had planned or intended to take YFN Lucci out. Okay. Let's say if they later discovered that, okay, maybe this guy weighed, I don't know, let's say he weighed, let's just say they came to the realization that they could not take him out. The fact that they did not succeed, that is not a defense to what is this, a conspiracy to commit a murk, which is, I believe, what the prosecution is alleging under these circumstances. And then we're going to go to withdrawal because that's really that's okay. I need to stop over explaining. So there's a general rule, and that general rule is that withdrawal is not recognized as a valid defense to conspiracy because conspiracy is complete as soon as the parties agree to commit a crime and an overt act is committed. Okay. I think that is self explanatory. So down the line, if Woody or Lil D came out and said that, okay, I know we had initially agreed to, do this to wife and Lucci, but I no longer want to do that. If they had already gone out and placed this phone call, or if they had already gone out and, I don't know, produced a shank or something along those lines, the later withdrawal is not a valid defense. It's not a proper way of a defendant to disassociate themselves from the conspiracy. Okay. And then again, just further on withdrawal or disassociation, while it may cut off further liability for a crime committed in furtherance of the conspiracy, the withdrawing co-conspirator must communicate his withdrawal to each of the co-conspirators. And that's why I keep emphasizing that conspiracy is a tool for the prosecution. And I guess that's why I am kind of worried. Worried is not really the right term, but that is why I foresee a conviction on that conspiracy on the conspiracy charge. And the reason, again, in order for these defendants to be able to disassociate themselves from YSL, they would have had to communicate this literally to each and every single member. And then there's, there's a different position on that, but I am going to cap it here. Yeah, I think we've discussed, we've discussed RICO at length. We've discussed conspiracy at length. I also went into, what is this? The credibility of Lil Woody. But then again, I don't know how much of that was on the stream because, I mean, my feed did go out. And then I'm just going to address this last question by Brooklyn. If Brooklyn's still here, I don't know if this is a question or a statement, but I need to put my glasses on for that, and I need to enlarge this. All right, so let's see. Brooklyn is saying there was a lot of uncredible witnesses. I have a problem with so many times the judge told the jury to strike the testimony. That is not how do I put this? Okay, I don't know why Brooklyn would have a problem with that because that is proper procedure, and it is in the defendant's interest. It is in the defendant's interest for the judge to instruct the jury to disregard testimony that otherwise should not have been elicited. Okay. As far as whether the witnesses in this trial were not credible, that's really up to the jury to decide. But my main thing is that while, again, the thing is, what we have to keep in mind is that as spectators, our interests are completely different from the jury's interests. And even some of the evidence that a lot of folks probably would give a lot of weight to, the jury might give very little weight. So it just depends on what the jury's interests are and what they're going to focus on. But I'm going to maintain that while who's this? What's his name? Woody was certainly entertaining to watch on the stand. His testimony to a large extent did help the prosecution out, okay, especially when his statements, I believe his statements were admitted. And I'd go back to credibility again because we have seen, or at least because Taisha's testimony is a bit more fresh because that is from last week, if I'm not mistaken. But even if we have to take a look at Taisha's testimony, okay, a lot of folks, if you visited a lot of the channels that have covered or are covering this trial, at least as far as the comments are concerned, Taisha has been praised because folks were under the impression that her testimony did not really what is this? Did not really dig, what's his name, SB's grave, or that's a terrible way of putting it. Or at least a lot of folks were arguing or was saying that Taisha, she was 10 toes down. Her testimony did not really do much. It did not really add value to the prosecution's case, which I've always completely disagreed with because Taisha's testimony, I mean, she did talk about how she's the prettiest girl he's ever dated and how he and how he was at the studio singing songs about her and the like, and how she calls him Bae. That was entertaining to watch. But apart from that, her main reason for being on that stand is to put that FN handgun or firearm in SB's hands. Okay, so I would not really I would not really consider, I'm just not considering um a lot of opinions from lay individuals. And the reason why I'm not doing that is because the jury will not be deliberating in a vacuum, okay? The jury will be guided by the what is this? They'll be guided by the jury instructions and the charge that the court is going to give to them. And under the four walls or four corners of criminal procedure and the law of evidence and even criminal law as a whole. Um, a lot of those jury instructions are crafted in a manner that leads to a certain result, because a lot of them are really, they're supposed to be neutral, but if the prosecution has presented enough fact to prove that case beyond a reasonable doubt, then that leads to a conviction on the count in question. In any event, I have done a lot of talking. We've gone from we've covered a lot. I had no plans. I had no plans of being here until 2:15, because this was one of those nights when I actually wanted to be in bed at least around 1:30. But that's it. Thank you for tuning in. This is the Anonymous Attorney, and I will be back. I'll be back tomorrow. I need to stop saying tomorrow because it's really today. So I'll be back on Sunday, 9 p.m. Eastern Time. I want to cover a bit of the lyrics, though. I want to cover the lyrics. We want to talk about admissions by the defendants, at least in the form of their lyrics and Instagram posts and things of that nature. But I don't know. I think that that's more reserved for a day when I have a lot of time. We'll see how it goes. But in any event, as far as Sunday, I'm starting at 9 p.m. I'm hoping that if we do go past that, if I do go past an hour, at least I'll be in bed by 11. So in any event, thank you for tuning in. And Brooklyn, if you're still here, thank you for the interaction. I appreciate that. And I am signing out.